calling some of my friends. I feel like going to a club and partying, cause I'm a soldier girl in this world. I stand alone, can be strong. I walked the miles and made it home. It's good to know without you I made it. Soldier girl in my world, I took the fall. Now I stand tall, all the pain and all. I made it through, and now all I've gotta say to you is salute.
La Costa Nostra, the legendary family. La Costa Nostra, the legendary family.
All right, I had to get that sound right. So now in I hear it. Everything going good. Let's go.
Gang, shit. They back in the city, got game in the city. I don't think you niggas really hear me. Got a fly ass nigga dance with me. Y'all know you always ain't really fucking with me. Some other niggas in the city real gritty. Upset in my paper and minding my business. But I stand on that real shit. I make a bitch for some food clip. Pull up on me, you might get shot. I be the one saying fuck the cop. Bitch, do I look like an Octobi? I'm checking your spot just like the cops. I heard you was fucking with the op. Played on my time, you might get shot. Told y'all niggas that I run the stop, but you run your mouth just like a slut. Bitch, who you talking to? I'll beat your ass like your mama do. I roll up in your spot, what you wanna do? Lightning bolt, who's loving you? I got so much shit that I wanna do. But when it's my time, no one coming through. And I'ma get mine, and then I'm through. I'm busting at everything coming through. I get off my shot. I didn't hit the block. I'm looking for odds. I'm chasing that Glock. Yo, when it's gon' stop? I'm always on top. Ain't never gon' stop. Yo, I can't be stopped. I'm riding this beat. I put him to sleep. Yo, this shit get deep. Yo, I never sleep. You won't get no peace. Fucking with me. And I play this beat. Yeah, gang shit. Let it ride. Let it ride.
All I dream is burn. If you get caught outside, then you gon' get burned. Niggas say the word and we gon' burn. We gon' burn. We gon' burn. Bloody nightmares, all I dream is burn. If you get caught outside, then you gon' get burned. Niggas say the word and we gon' burn. We gon' burn. We gon' burn.
Fuck as you all. Fuck as you niggas is on. We kicking the door, we busting the floor, we getting your family gone. Blood in the air, I'm smelling it down. No stopping the bully, I'm gunning you down. You niggas is kings.
Yo, can I with you? What?
ACT, did you see this?
Look, if it ain't official Dana J, Levi for Kelly, Prima Donna News, I don't even want to see it. Take the phone. Look. You got some weed? Gotta get some. All right, hurry up. Diesel and them here, everybody here. We waiting on you. All right.
But I know that there's more. More for you, more for us.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
Say you love it, what you gonna do now? Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect you. We have tomorrow, but tonight I wanna spank you. That ass, girl, gotta make it last now. Start off slow, then I'ma beat it up.
Against me shall prosper.
What up? 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 What's going on, Dream Team? How you doing? How you doing? Yo, yeah. Let's get it in real quick. Let's get it in. Oh, yeah. No, that's back this way. All right. Do like this. Okay. Cool. Nope. Let's do it this way. I fix it. I don't know how I did it, but I fix it. Dream Team, how you doing? 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 What's going on? What's up? What's up? What's up? What's up? Ooh. Let me fix that real quick. All right. So, hey, how y'all doing? How y'all doing? Hello, everybody. Hey, Ms. April Showers, how you doing? Ms. Delaney, what's going on? What's going on? What's going on? We gonna talk these motions. This motion that the government put in. It's pretty lengthy. So what you need to do is go and get somewhere that's comfortable. Go get you something to drink or something to eat. Because tonight I'm going to go through it. And I'm going to talk about some other things too. Okay? So shout out to the Dream Team. Everybody that's here. Yeah. Y'all see it across the top. If you want to donate to the page, you can hit the super chat at the bottom of the page, which is a box with a $sign in it. You can also hit my Cash App, which is $ official Dana J, or you can hit my tip jar, which I shortened it very, 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 very short. Very short. What's up, Keith? Dana, I can't never find that JD's when I'm in Atlanta. Man, you gotta holler at me. Holler at me. I tell you where to go. So my tip jar is https:// Streamlabs, streamlabs.com/DANAJAY/tip. That's it. Go in there and do your thing. Whew. Man, these lights get hot. Good God. And I got the air jumping. But hey, we're going to get into it right now. I ain't even going to waste your time. We're going to get into it right now. Not right now, but right now. Thank y'all for coming over and joining me. Y'all know what it is. We're here to make a change of what's going on the social media stuff. We don't got time for the bull crap that's going on. No, we don't. We hate what's going on. I'm telling you, we hate it. So, we there. We there. We there. Nice and big for you on the screen. Hold on for a second. I'm going to get me something to drink because 45 pages. Good Lord. 45 pages. Good Lord, that's a lot of pages. 45 pages. Good Lord, that's a lot of pages. Let's go grab what we need. I'm going to put some bio steel in me. Man. Let's get it going. Let's get it going. Here we go. I'm back. Oh, yeah. Let's go. United States of America versus Robert Sylvester Kelly, a.k.a. R. Kelly Durrell McDavid, and Milton Brown, a.k.a. June Brown. Oh, not yet. All right. The government consolidated motions in Limine. Uh-oh. Here we go with this again. The United States of America, through its attorney, John R. Losh Jr. Now watch this. See, see this right here? I would have destroyed that. Because I would have definitely put it in the motion. When have you talked to the United States of America? When have the United States of America wanted to file charges? You can't answer that. But the United States of America, through its attorney, John R. Losh Jr., United States Attorney for the Northern District of Illinois, respectfully moves the court in limine for entry of orders admitting or excluding certain evidence and argument at trial in this case, and set forth below. 1. Motion to protect the identities of certain victims, witnesses. The government moves to protect the identities of the victims named in the superseding indictment referred to as Minor 1, Minor 3, Minor 4, and Minor 5. My question, and Minor 6, the victim witnesses. Now, I got a question. What about Minor 2? Where's Minor 2? Where's Minor 2.5? Where's Minor 3.6? See what I'm saying? They want to play games, so let's do this today. I'm feeling good today. Who are expected to provide and or will be the subject of sensitive and personal testimony concerning illegal sexual abuse and the production of and receipt of child pornography by the defendants. Well, minor one is Lisa Van Allen, according to what they put in as a superseding indictment. Specifically, a lot of people saying, "Oh, that's Rashana." No, that's not what they said. If you go back and read what they put out, but they specifically said that this particular minor, something to the factor of, because I'm not going to say it word for word, something to the factor that the minor wanted to buy back the videos. So only Lisa Van Allen wanted to buy back the videos to be minor one. Okay. Who are expected to provide and or will be the subject of sensitive and personal testimony concerning illegal sexual abuse and the production of and receipt of child pornography by the defendants. Okay. Hold on. Don't y'all hate when you live and then people just... That was my daughter texting me. I ain't even answering that back. Dad, what are you doing? I'm on live doing what I always do. Blog. Okay. Specifically, the government moves the court to 1, permit the victim witnesses to testify using their first names only. 2, limit references to each of the victim witnesses in open court to their first names only. And 3, prevent public disclosure via cross-examination or otherwise of the victim witnesses' respective addresses, full names and family members, or exact places of employment, if any. Jesus. The superseding indictment charges defendant Kelly with multiple counts of sexual enticement and exploitation of the victim witnesses. The victim witnesses are expected to testify in explicit detail and or be the subject of highly sensitive and personal testimony concerning Kelly's illegal sexual contact with them that occurred when they were between the ages of 13 and 17. 13 and 17? Okay. Due to the sensitive nature of the testimony and evidence relevant to the crimes charged, the government seeks entry of a proposed protective order limiting the disclosure of the victim witnesses' last names and other identifying information in court. The limited protections requested by the government are necessary and appropriate to protect the victim witnesses' safety and well-being, avoid harassment of the victim witnesses by the press and others, and prevent undue embarrassment and other adverse consequences such as retaliation by Kelly's supporters, relocation, or loss of employment. What the fuck? Yo, you gotta laugh to keep from crying, man. Everything that them folks have did now is coming up in Chicago. Jesus Christ. Stalking Azriel, cutting off the head of Azriel, talking about... See, this is crazy. And you see what it say, such as retaliation by Kelly supporters. This stemmed from all the stuff that's been going on from certain people and from that telephone call. And I'm going to be honest with you. They seen what happened to me. They seen what happened to me. They seen and what happened to Georgia girl. They seen what happened to other people. They are on the internet, people. They are looking at this full force. But yet, people get on here. That's why I just shut up. That's why I stopped even talking. I stopped threatening. I stopped all that. It wasn't worth my time. But it says, and prevent undue embarrassment and other adverse consequences, such as retaliation by Kelly supporters. Rob, don't you know them people? Relocation or loss of employment. Damn, there it is. There it is. And what's up, Big Bob? It's right there. How would they know if they're not watching of any retaliation by Kelly supporters? Now watch this. Them people ain't even Kelly supporters. Them people are not Kelly supporters. But everything I went through from that terrorist group is right here in the motion. Well, I bet they can't say Dana made the motion. In addition, the government anticipates that Minors 1 mother will testify about similar topics related to Minor 1. Oh, no, Minor 1 might be, wait a minute, I don't know. Including Kelly's long-term abuse of Minor 1 while she was a child. Okay. As a result, the government similarly moves to permit Minor 1's mother, who has the same last name. Oh, okay. They trying to make and Rashana, okay, and her mother testify. Okay. Who has the same last name as Minor 1 to testify using her first name only. Okay. The proposed protective order also contains a provision related to individual D, who will testify about, among other topics, sexual contact that she had with Kelly and Minor 1. Okay, individual D is Lisa Van Allenden, allegedly, and Minor 1 over the course of several years. The government seeks to preclude disclosure of individual D's address, names, and family members, and place of employment at trial and during pretrial and post-trial proceedings in this case. This case was charged in July 2019. And since that time, the case has garnered significant attention from local and national media sources. The same is true for Kelly's federal prosecution in the Eastern District of New York, EDNY, United States versus Kelly case number. Okay. In the EDNY case, the court granted the government's motion to exclude references to victims' last names and other personal identifying information during the trial. In sum, a balancing of the risk to the victim witnesses against the defendant's interests supported permitting the requested limitations. The victim witnesses testified about humiliating and explicit acts of abuse, some of which took place when they were minors. The same protocols are warranted in this case. Several district courts have excluded mention of victims' full names at trial, citing the privacy interests of the victims. CEG United States versus Campbell, okay. And C United States versus Nichols, okay. Victim's last name, okay. In sex trafficking case, protective order entered precluding reference to adult victims' last names and requiring all documents disclosing the last name of any victim to be held to be filed under seal. United States versus Ghana. Okay, we got all that. Given the anticipated explicit and sensitive nature of the evidence in this case, the government has a compelling interest in limiting identification of the victims. United States versus Paris. 1. Excluding mention of adult and minor victims' full last names at trial. As the government has a legitimate and substantial interest in protecting these witnesses from the likely adverse personal, professional, and psychological consequences of publicly linking their identities to their past lives as sex workers. As the Gardner court held, excluding evidence of the victims' full names is consistent with the Crime Victims' Rights Act, 18 U.S.C. 3771A and 8, which states that a victim has the right to be treated with fairness and with respect for the victim's dignity and privacy. 2016 WL at 6. Additionally, the government has an interest in encouraging crime victims, particularly victims of sex crimes, to testify by protecting them from some of the adverse consequences of their testimony. See Thompson 178. While the public has a constitutional right of access to criminal trials, that right is not absolute. Globe Newspaper Company versus Superior Court of Norfolk County. Okay. A court can inhibit the disclosure of sensitive information when it is narrowly tailored to serve a compelling governmental interest. In this case, the exclusion of the victims' last names, while otherwise allowing their testimony in open court, is narrowly tailored to serve the interest in protecting the victim's privacy rights. See Thompson 178. The court cannot envision a protective order barring mentioning of victims' full last name that is more narrowly tailored to serve the government's compelling interests. Also see Gardner 2016, W540 4207 at 4-5. Excluding mention of an adult victim's full last name at trial, explaining that use of the victim's full name would add nothing substantive to her in court testimony that cannot be supplied by the use of her first name and first initial of her last name. For the reasons set forth above, the government respectfully requests that the court grant the government's motion and 1, permit the victim witnesses and minor one's mother to testify using their first names only. Limit references to each of the victim witnesses and minor one's mother in open court to their first names only. And 3, prevent public disclosure of addresses, full names of family members, or exact place of employment, if any, for the victim witnesses, minor one's mother, and individual D. The government further requests that the court enter the attached protective order that sets forth the government's requested relief. The proposed protective order supplements the existing protective order in the case, R53, which contains several provisions regarding the disclosure of discovery materials produced in this case, including a prohibition on including any information marked as sensitive in any public filing with the court. 2, motion to preclude evidence of victim's sexual history. For the reasons set forth below, defendants should be precluded from eliciting on cross-examination or otherwise introducing evidence or making arguments as to the sexual behavior of the victim witnesses with individuals other than Kelly or others at Kelly's direction. No. If you're going to put Rob's whole life and sexual history online, put theirs online too. No. What's good for the goose is good for the gander. No. If I was Bonjean, I definitely attack that. A, the evidence is inadmissible under Rule 412. By its plain terms, Rule 412 bars evidence of a victim's sexual history and sexual predisposition in cases involving allegations of sexual misconduct. The following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. 1, evidence offered to prove that any alleged victim engaged in other sexual behavior, or 2, evidence afforded to prove a victim's sexual predisposition. Okay, so the federal government's trying to box Robert in now because they don't want Robert to put none of his proof up there, but they want to put all of their made up stuff up there. Okay, let's do it. The purpose of the rule is to safeguard the alleged victim against the invasion of privacy. Well, wait a minute. What about Rob's invasion of privacy? Didn't the government invade his privacy? So is it that Robert don't matter? It's just those females matter? Potential embarrassment. What about Robert potential embarrassment? And sexual stereotyping. What about Rob's sexual stereotyping? At the end of the day, what about Robert? He's a man. He's not a corporation. So if these females can do that and get that type of privacy, why can't Robert get that type of privacy? Come on. That is associated with public disclosure of intimate sexual details and to encourage victims of sexual misconduct to institute and to participate in legal proceedings against alleged offenders. Well, let's go here. If his sexual history going to be put on blast, why can't everybody else's? This should be a two-way street, not a one-way dead end. I'm just saying. This purpose is consistent with other provisions of federal law, which provide that all crime victims have the right to be treated with fairness and with respect for the victim's dignity and privacy. Consequently, Rule 412 is interpreted broadly and applies to all sexual behavior of the victim before trial. United States versus Torres, whether offered as substantive evidence or for impeachment. Advisory Committee notes, Rule 412 imposes clear limits on a defendant's ability to introduce evidence that a victim engaged in other sexual behavior or has a propensity to engage in sexual acts. In the context of criminal cases, the rule prescribes very limited exceptions to this inadmissibility. The court may admit the following evidence in a criminal case. A, evidence of specific instances of a victim's sexual behavior, if offered to prove that someone other than the defendant was the source of semen injury or other physical evidence. B, evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct, if offered by the defendant to prove consent, defendant to prove consent, or if offered by the prosecutor. And C, evidence whose exclusion would violate the defendant's constitutional rights. If a defendant intends to introduce evidence of a victim's other sexual behavior or alleged sexual predisposition under one of these exceptions, the rule requires the filing of a sealed motion no less than 14 days before trial that specifically describes and states the purpose for which it is to be offered, with notice to the victim or her representative. Fed R Evidence 412C1. None of the limited exceptions to Rule 12 apply in this case. Kelly is charged with enticing each of the minors named in the indictment to engage in sexual contact and acts with him repeatedly over the course of years. Here, any evidence of a victim's sexual behavior with anyone other than Kelly or others at Kelly's direction, as well as any evidence of any purported sexual predisposition, would be wholly irrelevant to the charges against the defendants. The exclusion of evidence on these topics and thus appropriate under Rule 412, see e.g. United States versus Isabella, 918 F3D. Prosecution affirming district court's decision to prohibit the introduction of evidence suggestive of the minor victim's sexual predisposition and her previous sexual activity with a male depicted in photos on her phone. What? Let me read that again. Wait a minute. The exclusion of evidence on these topics and thus appropriate under Rule 412. Prosecution affirming district court's decision to prohibit the introduction of evidence suggestive of the minor victim's sexual predisposition and her previous sexual activity with a male depicted in photos on her phone. Wow. B, the evidence is inadmissible under Rule 403. Even if evidence concerning the victims of the sexual conduct was relevant, it is not. Any probative value would be marginal at best and substantially outweighed by the dangers of unfair prejudice, confusion of the issues, misleading the jury, and embarrassing the victim. And it should be excluded pursuant to Rule 403. In particular, such evidence would provide for the substantial risk that the jury will question the victims' sexual morals and view them as untruthful because of their prior sexual activities. Stop. So the government don't want the jury to look at the accusers as whores. Let's put it out there, and as prostitutes. But they want the jury to look at Robert as a sexual predator. Make that make sense. You don't want your witnesses, government, to look like what they are. But you want Robert to look like something that he's not. How fair is that? How fair is that? BMW Monroe, you hit it on the nose. In other words, just show up, receive the guilty verdict, and be sentenced to life. Bullshit. That's exactly what the government is trying to say. For all of these reasons, any inquiry or evidence related to the victim's sexual history is properly excluded under Rule 403. 3, motion to bar evidence and argument related to consent. God. So they trying to bar everything. The government requests that the court prohibit defendants from introducing evidence and arguing that the minor victims consented to engaging in sexual activity while they were minors. What? It is well established that minors lack the capacity to consent. And so sexual contact with a minor is always without consent. United States versus Rogers. Wait a minute. You can't say that, because if they changing federal cards and sneaking in, as a matter of fact, and not even sneaking in, and using those federal cards to get past federal agents in court, or agents period in court, that's a violation of the court. So basically, and what you're saying is that, and you want the court to overlook what they done to get to this man and lie to this man, but you want to prosecute this man for stuff that went down behind their lie. Make it make sense. This is Brittany Monroe. Don't get mad at me. What up, Britt? What up, Britt? Nah, Brittany, I ain't mad at you. But I'm trying to figure out, because now they're trying to use case law that probably don't apply. And I'm going to look at these case laws. And what I'm going to do, I'm going to go and I'm going to talk to some lawyers, some federal lawyers about these case laws. And I'm just going to get some proper advancement notice about this. So, because the district court was correct as a matter of law that consent is not a defense to the crimes charged, wait a minute. It was not an abuse of discretion to exclude the consent evidence. So we overlooking what happened. How do you know? See, I can get into this real ugly. I'm going to go here. Again, I'm going to use Geronda because a lot of this is Geronda in Chicago. I'm going to go here. I'm really going to go here because I want y'all to see this. Hold on. See, this is what they don't want. So I'm going to literally go there with the government. Go to recents. Bang it out. There you go. I'm going to go there with the government, right? Here's what I'm going to say. See, because this proves it all. It says, "We love you, Rob," Geronda Johnson cried, earning a stiff arm wave from Kelly. Johnson was 18 with the ID to prove it. So I'm going to go here and I'm going to finish reading this. And plan to spend the next few weeks at the courthouse testing her personal system of justice. If he's hot, he must be innocent. I've seen that tape. That ain't him on the tape. He wouldn't do nothing like that, Johnson said. So what would you say if R. Kelly asked you out? I inquired. Yes, he ain't even got to finish the sentence. What if he wanted to tape you? Johnson paused a beat. Just don't let it go public. Okay. So with that being said, this lady went to this man's house, jumped the gate, told Bubba she gonna break him off, got in his house, took pictures on his bed, wrote a book about it, made it seem like R. Kelly had her locked in. Let's go here. BMW said, "Hello, everybody. Let's go here. Geronda is showing everybody that she's 18 with an ID, right? R. Kelly. She gets in R. Kelly's face. She ready to give it to him, right? Mind you, I just read what she said to the inquirer. I meant to the person for the had an ID. I just read to you what she said, right? All right. So with that being said, I'm gonna ask this question. Based on what she said, right? Based on what she said, do you think, and I want y'all to use logical sense, do you think, once again, I want y'all to use logical sense, and I'm going to put it back up here. I want y'all to use logical sense now. Do you think, listen, do you think that when her and Rob was smashing, she said she was 16? Put a yes if you think that she disclosed that she was 16 then, or put a no. Based on what she said. Based on what she said, I've seen that tape. That ain't him on that tape. He wouldn't do nothing like that, Johnson said. So what would you say if R. Kelly asked you out? I inquired. Yes, he ain't even got to finish the sentence. What if he wanted to tape you? Johnson paused the beat. Just don't let it go public. Okay. These are her words, not mine, not Rob. A person that's hard up like that, and I'm gonna keep it real. When a female wants the penis like that, she's not saying nothing that's gonna compromise her getting the penis. Same thing go for a male. When a male wants the vagina and is that far gone, he's not going, oh no, shorty, I can't do this. I'm 55. What? This is why I say people don't have real conversations no more. They want to attack Robert. They want to make Robert look like the bad person. Oh, let's keep it a buck. And the buck is Geronda did not. And I'm just going off of what I can assume because I wasn't there. So I don't know, but I'm just saying, I don't believe that Geronda said, no, Rob, no way, no how, not today. I don't believe Geronda said that. I believe Geronda said, you know what? I'm trying to see how far I can go with this. And that's just facts. I don't care what Levi say. I don't care what Larry say. I don't care what nobody say. Let's keep it real. Every male that's over the age of 20 have been in that position at least once or twice. And if you haven't, keep living. There's going to come a time. There's going to come a time when that fly got on my nerves. I hope I got that bummer. There's going to come a time when you're going to be put in a situation like that. Man and female. And if you haven't got there yet, just keep on living. And especially the way things going now. And you got 15-year-olds, but that's out there on the beat, prostitute. That's all you got to do is go on YouTube and look at the life on a corner in LA. They breaking it down to you. So I think there's a whole lot of people that need to be held accountable, government. So let's finish. That the minor in prostitution is not a defense to the crime of trafficking a minor for purposes of prostitution. And Raplinger, the defendant was charged with sexual exploitation of a minor in violation of 18 U.S.C. 2251A and E, distribution of child pornography, in violation of 18 U.S.C. 2252A, A1, and B1. The possession of child pornography in violation of 18 U.S.C. 2252A, A5B, and B2. The defendant agreed that consent was not a defense to the distribution or possession of child pornography charges. However, at trial, he sought to introduce evidence of the minor's consent as the sexual exploitation charge. To the sexual exploitation charge. Specifically, the defendant sought to introduce evidence that the minor victim consented to engage in the sexual behavior and lascivious exhibition. 555 F3D at 692. On appeal, the Eighth Circuit rejected the defendant's argument that such evidence should have been admitted and concluded that because the district court was correct as a matter of law that consent is not a defense to the crimes charged. It was not an abuse of discretion to exclude the consent evidence, the consent evidence. The Eighth Circuit further held that the jury was properly instructed that a minor may not legally consent to being sexually exploited. Let's go here. Since we're talking about child pornography and child reproduction, I believe Jim Darriaga should be charged. I believe Sparkle should be charged. I believe Michael Avenatti need to be charged. I believe the lady from CNN should be charged. I believe Daryl McDavid need to be charged. I know y'all saying, damn, Dana, that's a lot of charging, ain't it? Yeah, it is. Because when y'all have stuff like that, and Robert even said, like, yo, I'm not paying for that. Come on, bro. Robert never had the videotapes. And also, this is where the deep fake is going to come into play. Because now that these videos have to be authenticated. And what happens when the videos are not authenticated once again? What happens when the chain of custody has been broken in these videos? Are you going to still try to use them? Are you still going to try to use them? And let's go here. I've been told y'all that Lisa Van Allen hated Robert because he married Drea, right? Nobody wanted to believe me. Nobody wanted to believe me when I said it. So, let me see. Okay, put that there. Hold on. There it is. There it is. I want y'all to see that. I want y'all to see that. The jealousy. It says, I am Lisa Van Allen at Sunset Boulevard 91. How could I hate someone who hasn't done anything to me? I don't even hate Rob, and he used us all, to be honest. So Drea can speak about their old ass relationship, but I can't. Doesn't the world deserve the facts? I was the first to come out, and I'm not charging for my story. It's free. Here's the hate. Supreme Court, see y'all next. You already know what's going on. Here's the hate. So you saying, Lisa Van Allen, that Robert never did anything to you? Oh no, Drea never did anything to you. But you actually upset because you said, I don't even hate Rob, and he used us all, to be honest. So basically, because you're not number one and you're not the girlfriend, you're upset. Here's my question. Why? So because you couldn't be with Rob, you now want to try to take this to court to lie on Rob. Make this make sense? Rob ain't do nothing but make sure you were good. Even when you had Damon Pryor's baby while dealing with Robert, he still made sure you and your baby was good, which is now twerking her ass on Twitter and selling her booty on Twitter. I'm lost. And the government want to try to conceal y'all for what? Were y'all trying to be concealed and when y'all were winning awards in Birkin bags? So why conceal it now? Y'all won awards. Y'all won Birkin bags. Y'all won book deals. Y'all went on campaign tours. Why conceal y'all identity now when y'all want to go public to tell your story? I just don't understand. Are you telling your story or are you selling your story? So the defendant charged with enticement of a minor in violation of 18 U.S.C. 2422B proposed a jury instruction that would have required the jury to acquit him if it found that the victim induced him and was at least partially willing to engage in the alleged sexual conduct, which is all of them. Here's the key right here. The defendant charged with enticement of a minor in violation of 18 U.S.C. 2422B proposed a jury instruction that would have required the jury to acquit him if it found that the victim induced him and was at least partially willing to engage in the alleged sexual conduct. Stop. What did Yoronda do? She induced him. She coerced him. She led him to believe something different. When he told her no, what did she do? Oh, I want to press charges. No police report, but I want to go public. He gave me herpes. Herpes picked every other person, but not me. Make it make sense. The trial court refused to give the instruction and affirming the defendant's conviction. The Court of Appeals wrote, the defendant's argument collapses because he misconstrues the nature of liability under 2422B. His proposed jury instruction reflects this mistake. In effort, the defendant claims that entrapment by the victim ameliorates any inducement on his part. Again, this reading of the statute mistakenly changes the focus from the defendant to the victim. The victim's willingness to engage in sexual activity is irrelevant. What? In much the same way that a minor's consent to sexual activity does not mitigate the offense of statutory rape or child molestation, so long as the defendant's actions constitute the act of persuading, inducing, enticing, and coercing a minor to engage in criminal sexual activity. 2422B applies. How? Citation omitted. Okay. And United States versus Dye, the Third Circuit Court rejected a similar argument. In that case, the defendant was charged with enticing a minor in violation of 18 U.S.C. 2422B and traveling interstate for the purpose of engaging in illicit sexual conduct in violation of 18 U.S.C. 2423B. At trial, he admitted to the conduct alleged, but argued that the government's evidence against him was insufficient because the purported minor was a seductress who had persuaded, induced, and enticed him, not the other way around. The Third Circuit Court rejected this defense. Jesus Christ. The defendant's hot to trot defense is especially troubling because its underlying premise is that it is possible for a 14-year-old child to seduce a 36-year-old man. That's possible. Absolving the man of criminal liability for engaging in or attempting to talk the minor into engaging in illicit sexual activity. Now watch this. It's possible for a 14-year-old to seduce a 36-year-old. However, the 36-year-old need to ask for ID. If you think a person is underage, ask to see their driver's license. But that's how you hit them. Can I see your driver's license? If they say I got a learner's permit, walk away. I don't care how old they are. Because if you under 16 or under 17 or under 18, you should have you should have a permit. If you 17 or 18 or over, you should have a driver's license. If it don't fall in that statute, like in that category like that, man, walk away from that shit. Because if you 20 with a learner's permit, I'm not coming to get you all the time, and I'm not Ubering you everywhere. That means somebody lying somewhere. Somebody caught up somewhere. And you got to ask your folks, can you hold that car? 9 times out of 10 is going to be always at night. Nah, I'm good. I'm good. In this case, consent is not a defense to the charges on counts 1 through 4 and 9 through 13 of the superseding indictment. Whether any of the minor victims allegedly agreed to engage in sexual conduct with or at the direction of Kelly is irrelevant to whether Kelly is guilty of violating 2251A or 2422B. Therefore, evidence and argument related to the victim's consent is irrelevant and should be excluded at trial. This includes questions during cross-examination of the victims about whether they consented to having sex with Kelly or others while they were minors. Such questions would call for witnesses to make legal conclusions and should be barred. No. All questions should be there. Put them all on the table. For all these reasons, the court should grant the government's motion to bar evidence and argument relating to the minor's victim's consent. The government will offer instruction on this issue and its proposed jury instructions to be submitted at a later date. 4. Motion to prevent the public display of child pornography videos during trial. The court should prevent the publication of child pornography video clips. 2. The gallery during trial. There is no doubt that criminal trials are public events and that weighty concerns about the fairness and integrity of the proceedings require that criminal trials be open to the public. I'm going to stop right there. And they use case law of United States versus Curley. Check this out. If you want to prove this man guilty, right? The same way you showing it to the jury is the same way you can show that shit to the public. If not, you're going to have a discrepancy. If you really want to convict this man, be transparent. If you really want to say this man is doing something, be transparent. Let the public weigh in just like the jurors weigh in. I think it's only fair. You gotta let the public weigh in just like the jury weigh in. At the end of the day, what y'all saying and seeing, it could be anything. Just like the sham job in New York. Y'all didn't want nobody to see it, but then later on, y'all let the press see it. So what about the non-press? What about the people that matter but that pay y'all bills? That makes sense. If we gonna be fair about this, let's be fair around the board. Y'all want to be transparent about Robert, but y'all want to be secretive about the accusers. Make it make sense. The presumption of openness in criminal trials is not absolute. However, United States versus Gupta, the presumption of openness may be overcome only by an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. Press Enterprise Company versus Superior Court. Quotation omitted. Here, the overriding interest is the protection of minor one, who is depicted in the child pornography videos that the government intends to introduce at trial. The Supreme Court has found that child pornography creates a permanent record of a victim's abuse, and the very existence of that child pornography causes the child victims continuing harm by haunting the children in years to come. Osborne versus Ohio. Well, I have a question. Let's just say that Rashana, okay, let's just say that that's who they're trying to say it is, okay? In which they are trying to say that. Have she came out and said that anything is haunting her? Let's go here. Everybody talking about Dana. See, I told you she testified. Okay, check this out. Let's just say the government was able to crack her shell. Let's just say she get up on the stand and say, I plead the fifth. Then what? When you show the video, you have to show the same video from 2002. Anything enhanced in the video is nothing more than the chain of custody being broken. You got to show that same VHS video. That same one. And you can't have a DVD. And you can't show a clip of a DVD, but that's been enhanced. No. You have to show that same clip. And if you can't show that same clip, then guess what? Chain of custody is broken. On top of that, didn't Jim Daryaga say he viewed the video? So if he viewed the video, ain't that possession of child pornography? Ain't that watching child pornography? Isn't that a charge? No, but we don't want to look at the ones that's wrong, and we want to look at the man who didn't do nothing to nobody in that manner, but they want to make him guilty. The Supreme Court has found that child pornography creates a permanent record of a victim's abuse, and the very existence of that child pornography causes the child victims continuing harm by haunting the children in years to come. Prior to trial, the government will submit the clip portions of any screenshots of the videos that it seeks to use for review by the court and defense counsel. Wait a minute. Prior to trial, the government will submit the clipped portions of any screenshots of the videos that it seeks to use for review by the court and defense counsel. At this time, it is unknown whether there will be sufficient room for spectators to be seated in the courtroom. Here we go. At this time, it is unknown whether there will be sufficient room for spectators to be seated in the courtroom gallery. If there are spectators in the gallery, the government requests that all monitors facing the gallery be turned around or otherwise turned off so that spectators cannot see the child pornography being displayed on the screens. In addition, if there is to be an overflow courtroom where spectators can view this trial, the government requests that the monitors in any overflow room be similarly turned around or turned off while child pornography videos and images are displayed during the trial. Stop. Why would they seek for no spectators to be there? Why would this even be in their footnotes? Unless they trying another sham job in Chicago. So now they putting it out there. They pretty much don't want nobody there. They pretty much don't want nobody there. It says, at this time, it is unknown whether there will be sufficient room for spectators. So who else gonna be there? Who else gonna be there? I hate to say it, but the Bolingbrook stalker, he the only one that had time to sit down and count how many press people it was, because I wasn't counting all those people. However, this is where Chicago got to turn out. (495) U.S. 103 111. Victims of child pornography often write about their ongoing anxiety and fear that people who see them in public places will recognize them from the photographs that were taken of them as they were exploited. See improving responses to victims of child pornography. So who exploited anybody? Although the children cannot control that these images exist, this court can prevent the images from being publicly displayed during trial. But wait a minute. The video was publicly displayed years ago. Jim Dariagas publicly displayed it for everybody. Michael Avenatti publicly displayed a deep fake on CNN for the CNN promoters. But wait, here's the crazy part. Let's pause this right here because I started right? Let's pause that. While we talking about deep fake, make this make sense. While we talking about deep fake, right? Why did this come out? It says exclusive. Google, Facebook, Twitter will have to tackle deep fakes or risk EU fine sources. Google oversees CNN. Alphabet unit Google, Facebook, Twitter, TWTR.N, and other tech companies will have to take measures to counter deepfakes and fake accounts on their platforms or risk hefty fines under an updated EU code of practice. People familiar with the matter said on Monday. Make it make sense. Can I put that out there just to show y'all something? At the end of the day, oh snap. What is going on? At the end of the day, thought that was yo. It will not let me get back to where I was at. Okay. This is weird. This is really weird. I got okay. Now can y'all hear me? Got it. Yeah, computers be tripping after a while. So let's go back into it because this joint be just bugging. Share screen. Hold on. There's always something to try to slow me down. All right, here we go. Here you go. I got it. I'm back. There we go. All right, there we go. Here, the overriding interest in the protection of minor one, who is depicted in the child pornography videos that the government. Nope, that's not where I was at. That's not where I was at. Let's pass that. Here we go. The government has narrowly tailored its request to serve the victim's interests. The only accommodation that the government seeks is for the court to limit publication of the sexually explicit videos to the jury and trial participants while avoiding publication to the gallery. The government is not asking for any limitation on testimony describing such images. Requests to limit publication of child pornography are commonly granted. See United States versus Troop, number 12 through 36, 2012. Limiting display of child pornography images to the jury and trial participants, and finding that there is no particularly compelling reason why the public would need to see child pornography in the gallery during trial, and it would be detrimental to the minors depicted therein to put their victimization on display. In United States versus Seatman, this court granted the government's motion to prevent the public display of child pornography images and clips during the trial in that matter. Case number 18 CR 130. Okay. Further preventing the display of child pornography images to the public does not constitute plain error. United States versus Killingbeck. Finding no plain error where even assuming the restricting the that restricting the display of trial exhibits to the courtroom audience constitutes a partial closure for Sixth Amendment purposes. The government presents substantial reasons for doing so, limiting the continuing harm to victims of child pornography. United States versus Boyle. Finding no plain error where district court permitted the government to turn off a monitor facing the gallery during the display of allegedly sexually explicit images. 5. Government's intended evidence of polygraph examinations. At trial, the government will present evidence about polygraph examinations that were administered for multiple witnesses who were involved in the recovery of videotapes produced by Kelly containing child pornography. Stop. That means that old lawyer got to be involved. There we go. Now we got to go get the old lawyer. Now the old lawyer got to be summoned. Everybody got to be summoned for this. Everybody. And what's up, James? What up, Willie? What up, Georgia girl? J-Rock. Factual background. In summary, count 5 of the superseding indictment alleges that between 2000 and 2019, Kelly and McDavid conspired with each other, individual A and others, to conceal and cover up the existence of multiple videos depicting Kelly engaged in sexual contact and sexual acts with minors. R93, superseding indictment, count 5, 2 through 5. In approximately 2001, Kelly and McDavid learned that at least 4 of these videos, video 1, video 2, video 3, and video 4, were missing from Kelly's collection of child pornography. What? In order to conceal and cover up the existence of videos from investigators, Kelly, McDavid, and others agreed to collect the missing videos that depicted Kelly engaged in sexual contact with minors. It is alleged that Kelly and McDavid paid hundreds of thousands of dollars to individual A, individual B, individual C, and individual D in exchange for obtaining and returning multiple videos that they knew depicted Kelly engaged in sexual contact and sexual acts with minors. As a condition of being paid money for returning the videotapes, the superseding indictment alleges that Kelly and McDavid directed individual B and C and individual D to take polygraph examinations regarding whether they had returned all copies of such videotapes. Okay, so now we have the 2 guys and Lisa Van Allen in play, and also Lisa Van Allen ex-husband. Okay. The indictment further alleges that at the direction of McDavid on Kelly's behalf, individual C and individual D took polygraph examinations regarding the videotapes that individual C and individual D had returned depicting Kelly engaged in sexual contact and sexual acts with minor 1 and individual D, including whether they were additional copies of the videotapes. At trial, the government will call individual B and individual C and individual D to testify about their involvement in a conspiracy to recover and return videotapes to Kelly and McDavid depicting Kelly's sexual abuse of minor 1. Individual B, individual C, and individual D will testify about the communications that they had with the defendants about returning the tapes in exchange for financial compensation. They will testify about how, as a condition to receiving the promised payment, they were required to first take polygraph examinations about whether all such videotapes had been returned to Kelly and McDavid. The government also plans to call on or more of the polygraph examiners to testify about their involvement in administering the polygraph examinations of individual B, individual C, and individual D. Through these witnesses, the government will introduce testimony and documents related to the polygraph examinations that were administered on behalf of Kelly and McDavid. The documentary evidence, which is described further below, is relevant to the charged conspiracy, and that it demonstrates that the witnesses were subject to such examinations about the videotapes as a condition to their promised payments from Kelly and McDavid. For example, the government anticipates that individual D will testify that in 2007, she was required to take 3 polygraph examinations geared at determining whether she had returned all copies of the videotape that she took from Kelly that depicted individual D having sex with Kelly and minor 1. Okay, individual D is Lisa Van Allen. Video 4, individual D will testify Can y'all hear me? Can y'all hear me? Can y'all hear me now? Can y'all hear me? Yes, no, maybe. Okay. What about now? All right. 1, why McDavid required individuals to take multiple tests, and 2, why McDavid paid large sums of cash to individuals after it was reported that they passed the examinations. The government further represents that it will not use the results of the polygraphs to bolster the credibility of any witness and will not make any arguments regarding the scientific reliability of polygraph examinations at trial. Admission of the polygraph evidence for the limited reasons set forth above is permitted under Seventh Circuit law. The Seventh Circuit has given district courts considerable difference on the issue, indicating that the decision to admit polygraph evidence will be reversed only when the district court has abused its discretion. United States versus Resnick. In Resnick, the government presented evidence that during the execution of a search warrant on the defendant's home, law enforcement asked the defendant to take a polygraph examination, and the defendant refused to take one. In affirming the court's admission of this evidence at trial, the Seventh Circuit reasoned that this case is not in the end about polygraph evidence. It is about evidence of a refusal to take a polygraph. The same principle applies here. The government is not seeking to use the results of the polygraph examinations for their scientific value or to bolster the credibility of any witness. Rather, as alleged in the superseding indictment, Kelly and McDavid caused examiners to administer polygraph examinations in furtherance of their conspiracy to obstruct justice. It is also important to highlight that the offered polygraph evidence does not relate to polygraphs of any of the defendants in this case. As a result, there is no risk that the jury could make adverse inferences about the defendant's credibility, as the government is not offering evidence that any of the defendants took polygraphs. United States versus Bowen. Affirming exclusion of the evidence that defendant took a polygraph under Rule 403, because even if the facts about an exam were admitted without the results, the jury would still be reasonably likely to infer that defendant failed the polygraph. And some evidence of where, when, how, and why the polygraphs of individual B, individual C, and individual D were administered is probative evidence of the conspiracy charge in the indictment, including, for example, one of the alleged overt acts that McDavid, acting on Kelly's behalf, directed individual C and individual D to take polygraph examinations. And as such, this evidence should be admitted at trial. 6, notice regarding introduction of the false records alleged in the superseding indictment. The government provides notice that it will seek to introduce certain false records alleged in count 5 of the superseding indictment. First, the government provides notice that it will seek to admit a memorandum summarizing an interview of individual D that took place on or about July 26, 2007. This memorandum, which is not hearsay, is relevant to prove that McDavid and Kelly conspired to obstruct justice as alleged in count 5 of the superseding indictment. Particularly relevant to this motion is the allegation in the superseding indictment that On or about July the 26th, 2007, Kelly and McDavid directed individual D to falsely deny that individual D and Kelly engaged in sexual acts together with minor one. Huh? When Kelly and McDavid knew that Kelly had engaged in sexual acts with minor one and individual D, as Kelly and McDavid intended, a false record, document, and tangible object was prepared based upon individual D's false statements. Count 5. What? The memorandum of individual D's interview is the false document referred to in the superseding indictment. As set forth above, individual D was summoned to Chicago multiple times in 2007 in connection with McDavid and Kelly's effort to collect contraband videotapes and impede the Cook County criminal prosecution 2008. No. Lisa Van Allen said out of her own mouth, and she was not coerced and she was not forced. Lisa Van Allen said out of her own mouth, that she called Robert and told him about the tapes. We ain't gonna do that. Individual D was required to take multiple polygraph examinations to assure Kelly and McDavid that she had returned the video she took from Kelly that depicted herself, Kelly, and minor one engaging in sex acts while minor one was around 14 years old. Okay, I got to see that. Individual D is expected to testify at trial in this case that following her third polygraph examination on or about July the 26th, 2017, McDavid told her to meet with other lawyers and tell them that she never had sex with minor one. What? Individual D is expected to testify that McDavid waited in the hallway as she went in the room to meet with the lawyers and provide them with false statements as instructed by McDavid. Not by Kelly, but by McDavid. A memorandum of interview dated July the 26th, 2007 was prepared, documenting individual D's false statements. In summary, the memorandum states that individual D provided the following information. Between 1997 and 2006, individual D had sex with Kelly and multiple other females, all of whom were over the age of 17. Individual D knew minor one and had spoken to her on numerous occasions. Individual D never saw Kelly in a sexual situation with minor one. Minor one was never a participant in any sexual encounter with individual D and Kelly. Individual D agreed to be interviewed by attorneys on July the 26th, 2007. Individual D was not forced, threatened, or promised anything to participate in this interview. At trial, the government will question individual D about this memorandum and lay the foundation for the memorandum's admission into evidence. The memorandum should be admitted, as the statements therein are not being offered for their truth. What? The memorandum should be admitted, as the statements therein are not being offered for their truth. Quite the opposite. The government seeks to use the document as evidence that she was coerced by McDavid and Kelly to provide false information about her knowledge of minor one. So here's a question. Now we getting into he say, she say. Because there's no way you can prove the truth of that without going into what Lisa Van Allen versus what Robert Kelly versus what Daryl McDavid said. So at that point, it turns into he say, she say. Well, Lisa Van Allen said this. Daryl McDavid said this. Robert said this. June Brown said this. Who do you believe? Lisa Van Allen lost her immunity behind lying. And it was proven that it wasn't coerced, it wasn't forced, it wasn't enticed. Once again, violating the Fifth Amendment. This case was tried already. Double jeopardy. The government's evidence will further show that on or about July the 26th, 2007, individual D received a $30,000 payment from McDavid. In addition, the memorandum is not privileged. Oh. After the memorandum was prepared, Kelly's attorney at the time provided the memo to the assistant state's attorney assigned to Kelly's criminal trial in Cook County. The Cook County State's Attorney Office in turn provided a copy of the memo along with the correspondence from Kelly's attorney to the U.S. Attorney's Office, and the memo has been produced to the defendants in this case. Second, the government provides notice that it will seek to admit a police report containing false information provided by Minor 1 during the Chicago Police Department's investigation of Kelly in 2000. As alleged in the superseding indictment, in approximately December 2000, pursuant to instructions that Minor 1 received from Kelly, Minor 1 falsified and caused a false entry to be made in the police report. When Minor 1 denied to law enforcement officers that Kelly engaged in a sexual relationship with Minor 1. Don't she know who she having sex with? So how y'all gonna try to tell that lady she lying? At trial, Minor 1 is expected to testify. At trial, Minor 1 is expected. It's not saying that she is. It's not saying she's not. It's saying that she's expected. So here's the monkey wrench. What if she don't? What if she don't? So for all the people saying that she testified, that's not what the government's saying. The government's saying they expect her to testify. Well, expectations always can go wrong, can't they? Some expectations never materialize. I expected to be a millionaire by the time I turned 30. That didn't happen. Hey, Nita, I'm just saying. It says Minor 1 is expected to testify. So what if she never come? Or what if she just get up there and plead the fifth? It says Minor 1 is expected to testify that Kelly began having sexual contact with her beginning around 1997 or 98. When Minor 1 was 13 or 14 years old. Wait a minute. If you're going to charge somebody and you can't say 13 or 14, and you got to have a precise date. These dates are not precise. These guesstimatable. When Minor 1 was about 15 or 16 years old. Wait a minute. What the hell? At trial, Minor 1 is expected to testify that Kelly began having sexual contact with her beginning around 1997 or 1998, when Minor 1 was 13 or 14 years old. When Minor 1 was about 15 or 16 years old, and or about 2000. What? Certain government agencies began investigating allegations that Kelly was sexually abusing Minor 1. Kelly instructed Minor 1 on how to act and what to say if she was questioned. In or around December 2000, law enforcement officers from the Chicago PD questioned Minor 1 about sexual contact with Kelly. During the interview with Chicago PD, Minor 1 falsely denied the allegations of Kelly's sexual misconduct and documented that information in a police report. In summary, the police report states that law enforcement interviewed Minor 1, who stated that she had never been sexually abused by Kelly and that any such allegations are untrue. So I have a question. How can the government say that this lady is lying? Was the government there? At trial, the government will seek to admit the CPD report into evidence. Admission of this report is permissible. as it is not hearsay and is being offered to prove allegations in the superseding indictment. For all these reasons, the above described records should be admitted into evidence. 7. Government's notice of intent to admit direct evidence of crimes charged. As set forth in the superseding indictment, Kelly is charged with multiple crimes related to his sexual abuse and exploitation of 5 minors over the course of several years, counts 1 through 4 and 6 through 13. The indictment further alleges that McDavid knew that Kelly was sexually abusing minors and that Kelly made several videotapes documenting the abuse, count 5. Kelly and McDavid went to great lengths to cover up the abuse, including paying large sums of money to witnesses to ensure that they would lie to law enforcement about the criminal conduct. In furtherance of Kelly and McDavid's conspiracy to obstruct justice, it is alleged in the superseding indictment that Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelly could remain in control over them, prevent them from providing evidence to law enforcement, and persuade them to continue to abide by prior false statements relating to Kelly's sexual contact and sexual acts with minors and videos of such conduct. At trial, the government will introduce testimony and evidence of the physical, emotional, and sexual abuse that Kelly inflicted on minors 1, 3, 4, 5, and 6 over the course of several years. The victims will testify about how Kelly used violence and threats of violence to control, manipulate, and isolate them, all as a means to coerce the victims to have sex with Kelly and prevent them from reporting Kelly to the police. For example, the government expects that minor 1 will testify that Kelly began hitting her when she was around 17 or 18 years old. Minor 1, hold on, wait a minute. Time out. If he was abusing her, why did he wait for her to be 17 or 18? Why didn't he start hitting her and when she was 13, as the government alleges? That don't make sense. She was already around the man due to her parents and her brother being around Rob. So basically she was already around the man. So for all them years but that she was around, why would he start hitting her 4 to 5 years later? That don't make sense. When somebody is trying to show dominance, an abuser, from what I read, if an abuser is trying to show dominance, he's going to hit and do whatever off the back. The first time you say no, you're going to get hit, or you're going to get yelled at, or you're going to get threatened. Not 4 to 5 years later. You know what I mean? Minor 1 will also testify about how Kelly isolated her from her family and friends and controlled her every move, including who minor 1 was allowed to talk to. As another example, minor 5 will describe the strict rules that Kelly had regarding who minor 5 was allowed to speak to, and that minor 5 had to seek Kelly's permission before interacting with other men. Minor 5 is who? I got to go back and look at that. According to minor 5, there was one instance where Kelly punched a man after he told minor 5 that he thought minor 5 was cute. What? In short, Kelly used physical violence and emotional manipulation to entice and coerce the victims to have sex with him. Thus, testimony about how Kelly hit or otherwise inflicted physical violence against the victims is direct evidence of the 22422B charges. Now, wait. Why would Kelly have to use physical violence or emotional manipulation to entice and coerce accusers to have sex with him? We talking about R. Kelly. Any woman in the world will have sex with R. Kelly. So why do he have to entice or coerce people and threaten them? That's not making sense. Evidence of Kelly's physical abuse is also direct evidence of the charged conspiracy to obstruct justice, which alleges that between approximately 2000 and 2019, Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelly could maintain control over them. That sounds like a Jim Daryaga story. Prevent them from providing evidence to law enforcement, and persuade them to continue to abide by prior false statements relating to Kelly's sexual contact and sexual acts with minors and videos of such conduct. Okay. As a result, Minor One's testimony about Kelly's physical and emotional abuse of her while she was an adult is also direct evidence of the 371 charge. What? Okay. 8. Motion for prior notice concerning Rule 608B impeachment. The government moves to bar each party from introducing evidence, including by asking questions on cross-examination under Rule 608B, except upon prior notice to the court and the opposing party outside the presence of the jury. Rule 608B provides that specific instances of past conduct may be inquired into on cross-examination if and only if they concern the witness' character for truthfulness. By its very nature, impeachment based upon a witness' prior conduct that is not relevant to the matter at issue creates a risk of causing unfair prejudice to an opposing party. First, a party attempting to conduct such impeachment may erroneously believe that such impeachment is appropriate when it is not. The end result being that the impropriety of the impeachment is only discovered after the disparaging impeachment conduct is presented to the jury as part of the attorney's question. Second, even if some conduct may properly fall within the scope of Rule 608B, counsel may exceed any limitations on the scope to which such matters may be addressed on cross-examination. Third, depending on the nature of the past conduct raised by the examiner, the jury may not be able to completely obey the court's instruction to disregard the contents of an improper question heard by the jury. For these reasons, and to obviate any risk of unfair prejudice, the government asks that this court exercises discretion to preclude the parties from pursuing any impeachment under Rule 608B unless outside the presence of the jury. The party has made a prior offer of proof concerning the alleged prior conduct. Wow. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. Make those procedures effective for determining the truth, 2. Avoid wasting time, and 3. Protect witnesses from harassment and undue embarrassment. Procedurally, the government proposes that prior to cross-examination, the court should require each party to first notify the court and other parties at sidebar of its intent to impeach under Rule 608B. Hold that thought. Hold that thought. Hold that thought. I'm going to play another song. We're going to take a little break. Hold that thought. Let's play one more song. Let's see. Let's go. What can I play? Gotcha.
understands my needs. And I see nothing but love in those eyes when she looks at me. Yeah, she likes to cook and clean. And I don't worry much, cause she treats me like a king. And she don't put me down when her friends around. She keep my beers cold, I let my guards down. And yes, she is my lover and my friend. But I found someone better than you. She don't treat me like you do. I found someone better than you. And she don't treat me like you do. Now sometimes I come in late and she ain't mad, she just say, baby, how was your day? See, the girl's a breath of fresh air. It's like heaven sent down the answer to my prayer. Cause we don't argue, she don't sleep around. She's a good girl and I'm happy now. And yes, she is my lover and my friend. Well, I found someone better than you. She don't treat me like you do. Yeah, I found someone better than you. And she don't treat me like you do. But I found someone better than you. And she don't treat me like you do. I found someone better than you. And she don't treat me like you do.
All right. All right. We back. We back. All right, let's get back into it. Ooh. Let's get back into it. All right. Motion to preclude argument or evidence designed to elicit jury nullification. The government moves this court to preclude the defendant from arguing or otherwise presenting evidence of pursuing lines of inquiry designed to elicit jury nullification. It is well settled that it is improper for a defendant to suggest in any way that the jury should acquit defendant, even if it finds that the government has met its burden of proof. See United States versus LaGuardia. Court held that district court properly found that evidence offered by the defendant was irrelevant and served to only confuse the jury or invite the jury to acquit, even if the government satisfied each element of the offense. United States versus Perez. An unreasonable jury verdict, although unreviewable, if it is an acquittal, is lawless, and the defendant has no right to invite the jury to act lawlessly. Jury nullification is a fact because the government cannot appeal an acquittal. It is not a right either of the jury or of the defendant. United States versus Sepulveda. Okay. Holding that the court may block defense attorneys' attempts to serenade the jury with the siren of nullification. Therefore, the defendant should be precluded from presenting argument or evidence designed to elicit jury nullification. The government cannot anticipate each form of potential jury nullification argument or evidence. The government moves to exclude the potential areas noted below, all of which are irrelevant to the elements of the crimes charged, as well as any argument or questioning, no matter what its form, that in effect would encourage a jury to acquit under any circumstances, regardless of the applicable law or proven facts. United States versus Anderson. United States versus Daughtry. Motion to preclude argument or evidence concerning potential penalties faced by defendants if they are convicted. The government moves the court to preclude defendants from introducing evidence, making argument, or otherwise mentioning the potential penalties faced if convicted. For one, the Seventh Circuit's pattern criminal jury instructions include an instruction specifying in deciding your verdict, you should not consider the possible punishment for the defendant. If you decide that the government has proved the defendant guilty beyond a reasonable doubt, then it will be my job to decide on the appropriate punishment pattern criminal jury instructions. Additionally, the Seventh Circuit has stated that arguing punishment to a jury is taboo. United States versus Richardson, vacated on other grounds. Also see United States versus Lewis. The practice of informing jurors about the sentencing consequences of their verdicts is strongly disfavored. United States versus McKenzie, holding that while the Sixth Amendment requires that a jury determine questions of guilt or innocence, punishment is the province of the court. Argument and evidence concerning punishment are improper because the law is well settled that the potential penalty faced by a defendant is irrelevant to the jury's a determination of guilt or innocence. Shannon versus United States. It is well established that when a jury has no sentencing function, it should be admonished to reach its verdict without regard of what sentence might be imposed. Quotation omitted. Alawoli versus Carter. United States versus Frank. It has long been the law that it is inappropriate for a jury to consider or be informed of the consequences of their verdict. Mention of the potential penalties faced by defendants only will serve the improper purpose, of jury nullification. United States versus Reagan. The authorities are unequivocal and holding that presenting information to the jury about possible sentencing is prejudicial. Quotation omitted. Accordingly, the defense should be precluded from mentioning or introducing evidence about any of the range of penalties faced if convicted. What? So they trying to make it so that he can't do nothing. He just needs to show up and be sentenced and be stepped on. Motion to preclude allegations of outrageous government conduct. The government moves to exclude evidence or argument by counsel of outrageous government conduct. The Seventh Circuit repeatedly has held that the outrageous government conduct is not a defense in this circuit. United States versus Stallworth. Citation omitted. See also United States versus Sherman. United States versus Boyd. Outrageous governmental misconduct is no defense to a criminal charge, and the jury thus should not be exposed to irrelevant allegations of this sort. Furthermore, this court held that the issue of government misconduct was a matter of law for determination by the court. The issue of government misconduct is not an issue for the jury. United States versus Swedick. Noting that every circuit which has considered the issue has held that the issue is not a jury question. Citations omitted. Yet there is a tendency in criminal cases to try some person other than the defendant and some issue other than his guilt. United States versus Griffin. The thrust of the defense in these type of cases is this: the prosecution was not nice or could have done it better, and so the jury ought to acquit, whether or not guilt has been provided beyond a reasonable doubt. In the face of this tendency to interject themes of government misconduct into a defense strategy, courts routinely have granted motions in limine to bar defendants from presenting evidence or making arguments to the jury suggesting that they should be acquitted because of the government engaged in misconduct in the course of its investigation. United States versus Shields. Granting motion in limine to preclude evidence which is not relevant to defendant's guilt, but is designed only to persuade the jury that defendants should be acquitted because the government engaged in misconduct during its investigation. Accordingly, the government moves to bar the defense from introducing evidence or argument of outrageous government conduct. Oh, so the government is now acknowledging that they engaged in misconduct, and they don't want Robert and Jennifer Bongine to introduce that. Oh, makes sense now. Okay. Motion to preclude argument and evidence regarding the government's motivation and an investigation and prosecuting the case. So they don't want nothing to come out about Cook County or nothing. Man, hell no. The government moves to preclude evidence or argument by defense counsel regarding the government's and the officials and agents' motivations for investigating or prosecuting this case. This includes, but is not limited to, arguments that the federal prosecution or of defendants for child pornography offenses after Kelly's acquittal in Cook County Circuit Court is vindictive or otherwise improper. There you go right there. There you go right there. They telling you, they trying to get this thrown out. They trying to get this thrown out. Why? Because if you get that thrown out and you can't invoke the Fifth Amendment. It says this includes, but is not limited to, arguments that the federal prosecution of defendants for child pornography offenses after Kelly's acquittal in Cook County Circuit Court is vindictive or otherwise improper. Evidence bearing on the government's decision to prosecute is extraneous and collateral, and thus excluded from trial. See United States versus Johnson, 605 F2D 1025 1030, 7th Circuit, 1979, affirming the exclusion of evidence offered to show that the indictment was a political instrument. So they trying to cover for Kim Foxx. Affirming the exclusion of evidence offered to show that the indictment was a political instrument. Jesus Christ. Selective prosecution of a criminal defendant is not an issue for the jury to decide. Further, the government moves to preclude the defense from arguing or eliciting evidence regarding the mental states, subjective intentions, or motivations of the investigating officers and agents. It is well settled law that inquiries regarding the subjective intentions or motivations of a government agent are irrelevant to determining the factual guilt or innocence of a defendant. Jennifer Bongine need to destroy this. Even in the context of an entrapment defense, it was proper for the trial court not to allow the defense to mount an inquiry into the mental states of the investigating officers, since such evidence was irrelevant. Motion to preclude argument and evidence of selective prosecution theory. Man, come on, bro. They trying to take all this man rights. Similarly, defendants should be precluded from introducing evidence or argument seeking to present a theory of selective prosecution before the jury. During the trial, the government intends to call witnesses who, for example, participated in the conspiracy to receive child pornography. The government anticipates that defendant may argue that some of these witnesses may have been engaged in unlawful receipt of child pornography and have not been charged with any criminal offenses. Pursuant to federal rules of evidence 401 and 403, such information is irrelevant and unfairly prejudicial. Indeed, in United States versus Young, the court granted on relevancy grounds the government's motion to preclude the defendant from introducing evidence that another individual who had been arrested with him was not charged. And so ruling, the Young court noted that the primary issue for the jury was whether the government met its burden of proof as to the defendant's knowledge and whether or not another individual was criminally charged. Did not make the facts related to the defendant's knowledge and participation in the alleged crime more or less probable. United States versus abroad is a matter that is independent of a defendant's guilt or innocence, so it is not a matter for the jury. In the same vein, defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of minors 1, 3, 4, and 5, and 6 to prove the offenses alleged in the superseding indictment. The government expects to present evidence that some of the minor victims spent a substantial amount of time with defendants and that defendants may try to deflect the blame for their criminal conduct by offering evidence that the parents of the minor victims knew or should have known about their daughter's sexual relationships with Kelly. Defendants may further assert that to the extent the parents knew or should have known about the sexual relationships with Kelly, the parents thereby consented to such relationships. Such evidence has no legal bearing as to the offenses with which defendants are charged. Indeed, consent by either the parents or the minor victims is not a defense to such charges. That's bullcrap. Defendants may go as far as to argue that the parents of the minor victims were responsible for or aided and abetted defendants' crimes. Such arguments are legally irrelevant and would only serve as a distraction to the jury. For all of these reasons, y'all know what that say. Motion to preclude discovery requests for commentary regarding discovery in the presence of the jury. The government moves this court to preclude the parties from requesting discovery from witnessing or opposing counsel, moving the court for such discovery or otherwise commenting on discovery matters. In the presence of the jury, such requests in front of the jury may distract the jury or create the impression that one side has suppressed information as a means of seeking an unfair advantage. CEG United States versus Gray. Granting government's motion to preclude the defense from requesting or commenting on discovery in the presence of the jury. See also Thompson versus Glenmaid. It's another case law. Rather than focus on the issues in the case, the jury may instead be misled by the irrelevant side issues of the discovery process. Therefore, the court will not permit either party to refer to the discovery process in the presence of the jury at trial. Okay. As such, the government asks the court to prohibit either party from raising discovery issues in the presence of the jury. Okay. Motion to exclude evidence or arguments regarding the constitutionality of the states criminalizing the production and receipt of child. Whoa, wait. You can't bar. Wait a minute. Motion to exclude evidence or arguments regarding the constitutionality of the statutes criminalizing the production of receipt of child pornography. Statutes cannot overrule constitutionality. Arguments pertaining to the constitutionality of the statutes criminalizing child pornography offenses are wholly irrelevant to the indictment in this case and do not affect the Supreme Court's and Seventh Court's unequivocal rulings that the First Amendment and the Commerce Clause do not protect child pornography. What? See, Island versus Ohio. Rejecting a First Amendment challenge and upholding the constitutionality of laws prohibiting the possession and viewing of child pornography. United States versus Engel. Rejecting the Commerce Clause challenge to the conviction for possessing child pornography. For these reasons, the government moves to preclude defendants from introducing any evidence or argument regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. Motion preclude argument or evidence of non-pertinent traits of defendant characteristics. The government moves the court to exclude all evidence offered by defendants of their lawfulness and or non-corrupt conduct, except reputation or opinion evidence offered by character witnesses strictly in accord with the limitations of Federal Rules of Evidence 405A. So now the government don't want the defense to have none of their stuff, none of their evidence entered in, only character witnesses. This is crazy. This is crazy. This is their last hope. Other than testimony from character witnesses fitting within the narrow confines of Rule 405A, no such evidence is admissible. Rule 404A1 precludes the admissibility of evidence of a person's character or character trait to prove that on a particular occasion the person acted in accordance with the character or trait. Okay. Directs and relevant. What is that? Fed are evidence. 404A1, Rule 404A2 directs and relevant part that defendant may offer evidence of the defendant's pertinent. Even evidence offered under Rule 4 cannot include specific instances of good conduct. It is limited to a description of the subject's reputation or to a brief statement of opinion. Wow. Let's see. Pertinent trait. Fed are evidence pursuant to this rule. Only pertinent character traits of defendants are admissible. Wow. Motion to preclude defenses of alibi or unavailability and mental defect. What? Rules 12.1 and 12.2 of the Federal Rules of Criminal Procedure require that a defendant provide the government with notice of the following defenses: an alibi or similar defense that the defendant intends to raise, including any defense asserting that defendant's unavailability on or near the dates named in the indictment. Okay. Rule 12.1 and 2. Notice of any defense to be raised of a mental defect inconsistent with the state of mind required for the offense charge. On or about August 7, 2019, the government sent letters to defense counsel requesting notice pursuant to Rules 12.1, 12.2, and 12.3 of each of these defenses. The defendants have not notified the government of their intent to raise any such defenses. The government thus requests that the defendants be prohibited from introducing evidence or argument relating to such defenses at trial. 14. Motion to preclude defense counsel from defining the term reasonable doubt. Are you serious? So now they don't want them to define reasonable doubt. Jesus. The government moves the court to order the defense not to attempt to define the term reasonable doubt. During opening statement or closing argument, the term reasonable doubt should not be defined by the trial court or counsel. United States versus Anderson. That is because any attempt to define the term presents a risk without any real benefit. That is, any definition of the term often leans towards misleading and refinements that weaken and make imprecise the existing phrase. Reynolds, 64F 3D. Government argument was proper because it was invited by defense counsel's own improper attempt to define the reasonable doubt standard. United States versus Blackburn. Noting that definitions of reasonable doubt have a likelihood of confusing juries more than the simple words themselves. For these reasons, the Seventh Circuit has held that it is improper for attorneys to attempt to define the term reasonable doubt. United States versus Thompson. See also United States versus Clancy. Number case law. It seems simple enough. We admonish counsel, do not define reasonable doubt to a jury. Committee comment to Seventh Circuit pattern criminal jury instructions. 15, motion to allow government to recall the case agent during its case in chief. The government respectfully requests permission from the court to recall the case agent, a special agent from Homeland Security Investigations, during the course of trial so that testimony can be presented to the jury in an orderly and understandable manner and in a manner most effective for ascertaining the truth. This court has substantial discretion to determine the mode and order of interrogation. See United States versus Vasquez. Upholding district court's decision to allow government to recall law enforcement witnesses so the evidence could be presented in chronological order. So now they want to call the investigator that they had in New York. Okay. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth and avoid wasting time. Wow. Okay. They go in their statements and all that. Motion to admit business records pursuant to federal rules of evidence. Under Federal Rule of Evidence 90211, certified copies of domestic business records are self-authenticating if the party offering the records provides the adverse party written notice and allows the adverse party to inspect the exhibit and certification, allowing the party to challenge the authenticity of the records. Under Federal Rule of Evidence 8036, the records are an exception to the hearsay rule if the following conditions exist. A, the records was made at or near the time by or from information transmitted by someone with knowledge. B, the record was kept in the course of a regularly conducted activity of a business organization, occupation, or calling, whether or not for profit. C, making the record was a regular practice of that activity. D, all these conditions are shown by the testimony of the custodian or another qualified witness or by a certification that complies with Rule 902.11 or 12 or with a statute permitting certification. And E, the opponent does not show that the source of the information nor the method or circumstances of preparation indicate a lack of trustworthiness. The Seventh Circuit has consistently upheld the omission of business records. Okay. They going into their little spill with that. Then it says, conclusion. For the foregoing reasons, the United States respectfully requests that the court grant the government's motion in limine. The government will provide defendants with any additional certifications as they are received and the Seventh Circuit has allowed notice to be provided only days before trial. See United States versus Bledsoe. Seventh Circuit upheld the admission of business records pursuant to 902.11 certifications, even though the government gave the defendant notice of its intent to use the certification only 4 days prior to trial. Wow. Well, we see how the government coming. They lying all the way through. We see how the government coming. They lying all the way through. Sound like, hold on. Let me see what y'all saying. I'm going to start from here. Them hoes trying to hide their felonies. Facts. Throwing rocks and hiding them hands, but Jennifer is exposing it all. Blow by blow, she will drop some more stuff and hold them accountable. All of them going down. Watch her in action. Okay? They tried to have us all going in circles, but we've been seeing them play dirty the entire time. Facts. Servants of Lilith ain't slick. This is why Bonjean went ghost. Facts. They can't, though, at Midas. Spade. We saw most of the mugshots from Lisa's to Asante's to face. Right. See what they do is try to pile on bull. The government gone wild, y'all. This shows exactly how words are swords. Facts. Hit the like button, y'all. Yo, can I get at least 21 more likes? Right, Midas. But don't she get past us over here for sure. We know what's up with her. Okay. Sound like they want to hide everything they done wrong to this man and violating his civil rights. They trying their best. The truth will find its way out. Facts, Dark. Somebody said they ride. Stephanie said they riding dirty. Hey, Michelle. What's up, Clem? 21 more likes. That's all I need is 21 more likes. Yep, Dane, I've been saying that. Facts. So I'm gonna go here. I'm gonna go here because I'm gonna stay on this roll. I'm gonna go here. I'm gonna go here. I'm gonna go here. Lizette Martinez said, lock him up, throw away the key. And then it says, I am Lizette Martinez said, please do. Thank you at TMZ TV at Arthur Kitty. Well, here's the problem that I have with that. You want to lock up R. Kelly, but you was just soliciting R. Kelly. You was just stalking him on Twitter right before he went to jail. So I'm not understanding. And then I seen grown little boy say, see what happens when you bash the victim. What that's let me know is that if you believe everything a woman say, you just as crazy as that woman. If it's been shown that it's been lies and you talking about, oh, see what happened, bro, that's what's wrong. It's not enough men standing up for what's right. My question is, why didn't this come out when it happened? Everybody taking the Bill Cosby approach 30, 40 years later, and then all of a sudden you remember everything. Stop playing with me, man. But this one say, Kitty Jones, another one of R. Kelly's victims, tells us she has no issue with the prosecutor's recommendation. However, no amount of time will give her and others back their time or remove their trauma. Both women were featured in the Surviving R. Kelly docuseries, which sparked renewed prosecution and ultimately Kelly's downfall. And they say they'll be present for his sentencing later this month. So I have a question, because I'm going to love being there with them. I have a question. As I told everybody, Surviving R. Kelly docuseries, which sparked renewed prosecution, was the reason why he got booked. Lies. All lies was the reason why he got booked and in this situation. Okay, so let's go here. Kitty Jones. Who told you to quit your job in Dallas to be with Robert? Nobody. That's something that you wanted to do. So now Robert's wrong because he cut you off? And he said he ain't want it no more? I don't get it. Then we go to here. Then we go, oh, no. Let's go here first. Then you have Asian Doll that said, damn, R. Kelly was a sick biatch and he raped children. What WTF? This is the same woman that got beat up by a dude who got her face slashed, who got her body slashed over a dude who was a gangbanger from Chicago. And the fat baby, 305, said, I don't believe everything I hear. The moms was getting paid off their kids, and when they turned 18, they could no longer get money because they were old enough now. Facts, the fat, that baby 305. But then you have this big swollen ham hock named Khadijah McCutcheon that says, of course, you would say something like this, and woman like you is why little girls are afraid to speak out on what's going on with them. What if that was your child, niece, little cousin, or granddaughter? Woman like you disgust me. I will be going over to this tweet after I get off here, and I will be addressing folks on this tweet. I will be, because Khadijah went too far. And that's the problem with public perception. So now I'm gonna get into this. And I must say, to my knowledge, I understand that a young lady, right? I can't even call this chick a young lady, but this lady, or whatever the fuck she is, the hermaphrodite. I understand that she went over to Angie's channel and was talking about hijacking funerals. So I'm gonna pause that there. Y'all pause that, because I'm gonna get into that. Now it says, well, she said it, and she said it took a lot for me to put my page back up. Then it says, I don't like the evil things that's being said about me. All the false narratives and the threats. I don't have nothing to prove to social media. To the ones that know me personally, know my heart is gold, and my story will be told. This situation has mentally messed me up and traumatized me. Oh, Lord. And you got to put her on suicide watch now. Then it says, God got me. Broken heart, praying hands, long live trouble, my angel. Then the Shade Room posted, the woman who was with Atlanta rapper Trouble on the night he was killed speaks out. According to a statement collected by police, the woman, identified as Miss Williams, told authorities that her ex-boyfriend, Jamichael Jones, broke into the apartment they formerly shared. Stop. If y'all formerly shared it, whose name is on the lease? That's what it's going to boil down to. If Jamichael Jones' name is on the lease, he did not break into his apartment. You know what that means? He can invoke the stand your ground law. He went into his apartment and was locked. Another man was in there, and he broke the door down. Which means she's responsible for this. How's she responsible? First of all, if you know you just got an ex-boyfriend, right? Or an ex-husband, or ex-fiance, or ex anything. If his name is on the lease, if his name is on the deed, you do not bring another man to that house. Which also lets me know, because I know Trouble. Facts. He was comfortable with you, meaning he was dealing with you for a while. So it says, at the time, Trouble and the woman were asleep in the bedroom. The accused shooter allegedly woke her up by punching her in the face, then got into a dispute with Trouble. Jamichael then pulled out a gun and reportedly shot Trouble once in the chest before fleeing the scene. Jamichael turned himself into police on June the 7th in a hospital parking lot in Georgia. Facts. However, I got a problem with that. And I'm about to show you why. I'm about to show you why I got a problem with that. Excuse me. I'm going to show you why I got a problem with that. Go to your channel. Manage videos. This is why I got a problem with that. I want y'all to see this.
Dear Canty, I'm the Public Information Officer at Rockdale County Sheriff's Office, and the spelling is JEDIDIA. Canty is CANTY. Okay, so at approximately 3:20 this morning, Rockdale County deputies responded to a shooting. It was at the Lake St. James apartment complex in Conyers. Upon deputies' arrival, they observed the black male, lying on the ground suffering from a gunshot wound. Unfortunately, the victim did die on the scene. We do have a suspect. His name is going to be, what is his name? His name is Jamichael Jones. We currently do have warrants for his arrest, but right now he's not in custody.
Is there any connection between the victim and the suspect?
So there is no connection. What we know, what I can tell you, is that Mr. Morel Orr, which is the victim, was visiting a female friend at the complex, and Mr. Michael Jones did know the female, and it was a domestic situation.
Do you have any leads on where he might be at this time?
We don't have any leads. We did search the known locations that we thought he may be at, but we did not have any luck finding him.
Do you say it was a love triangle?
No, it's not a love triangle, not at all, because he was, the victim did not know the suspect.
That's a lie.
Was the female with the victim? Did they ride together to the complex, or he went to visit her?
I don't know that. I just know they were together at the apartment complex.
What would you say the message you have in the community?
Exactly what happened to Fernando.
Who might be afraid for their safety?
Coretta, you talking
I
to me?
wouldn't say that this has
She
anything
said
to do
Fernando.
with the
Wow, she
area.
took me back.
I think it was an isolated situation. It was a domestic situation. We are asking the public for their help in locating Michael Jones. He is from the Atlanta, Jonesboro area that we know of.
What words can you share about the victim? Obviously, he's a known person, and this is a lot of people.
Yep, it was in his name.
Yes. From what I know, I believe his name was Trouble. He's an Atlanta rapper. Unfortunately, I don't have too much information on it because I don't follow rap. But I know that there is a lot of people that are really upset right now.
Yeah, Vi, that's true.
Situation.
Can you say how many times he was shot?
He was shot one time. He was shot in the chest.
Was he awake or sleeping?
I don't know that.
Have you all been contacted the family members? I'm assuming if you put their name out.
Yes. The mother is aware, and I'm sure she's not dealing with it too well. I don't know if any
Most
of
deaf.
the members, but the mother was notified.
Most deaf, Vi.
When the complex was shot, inside, outside?
He was inside the apartment.
Is there any other details that you can share with us at this time? It seems the situation is a little...
So right now, the current warrants that we do have for the Jamaica suspect is we have home invasion. So that does tell you that he was at home. He entered the home, sorry. We have felony
Right,
murder.
Midas.
And we also have aggravated assault. So that's a little bit more helpful. So yes, we're asking the public if they know any, have any information about the incident, they can call the Rock County Sheriff's Office at 770-278-8188. Or you can call our main line at 770-278-8000.
Watch this. Right, Lil T. Right, Vi. Facts, Coretta. Watch this.
Let me know when you're ready. Ready? Okay, first spell your name.
This is going to be edited if I error.
Oh, yeah. All right. Okay, go ahead. So, first and last name and your title. Go button.
Eric Levitt, ERIC Sheriff of Rockdale County.
Okay. All right.
So earlier this evening, we created a plan of a knock and talk. The plan was to go out to all the locations that we were familiar with that the alleged suspect had visited or could have possibly been, based upon information that we have spoken to different perhaps witnesses or individuals. While out there doing the knock and talk, one of the locations we were at was his mother's house. While at the mother's house, mother received a phone call from, I believe, the aunt, which later ended up being a call from the son. And while mother speaking with the son, mother turned the son on to one of my sergeants, who began to talk to him and convince Mr. Jones to turn himself in. Mr. Jones agreed to turn himself in. He provided the time.
Hey, can I get 6 more likes, y'all?
He wanted to turn himself in as a peaceful turn-in. They received the time and location to turn himself in. We relocated to that location and just stood by. Sergeant Hines continued constant contact with Mr. Jones, as well as his mother was in constant contact with Mr. Jones. And I may add that his mother was a huge resource in helping us apprehend him. Nobody wakes up in the morning wanting a bad outcome. And so utilizing the mother and my staff trained and equipped to talk to individuals and know how to deal with individuals, was able to convince him to work with us and to turn himself into us, and that's what they did.
So you turned yourself into the hospital? Any particular reason why he just named the location for you?
I don't know the particular why. Maybe he felt that would probably be a safe location. Maybe it was an area that he was familiar with. But he decided that's where he wanted to turn himself in. It was a lit area. We were okay with it. It was near a hospital. Whatever it took to make him feel comfortable, but just turn yourself in, we were going to comply with that.
How did you figure out that he was the one that fired the gun?
Facts.
Well, as you know, this is still an investigation that is ongoing. And those details I cannot release at this time. But once we complete the investigation, if we can release that information, we do so at that time.
So you know he's your man, though?
We do know that. We feel strongly that he's our man.
Is there anything you can share with us that he said to you all? Any remorse? Anything?
I don't believe that he expressed any remorse right now, but we can tell based upon his impression or body language, if you will, that he's fear. He's fear for some sort of reason. I believe that's some of why he decided he wanted to turn himself in.
Hell about to break loose. He knows what's going to happen.
Threats to anyone? The female that was at the center of this? Anything?
To my knowledge, I'm not aware of anything that he's expressed.
His overall demeanor?
I have not saw him, so I couldn't tell you.
What is important about this that we have asked you like that?
So what's important is that the staff, my staff that's behind me, worked hard on this case from the time that it happened up until this date. And as you know, it's less than 48 hours, no sleep, no rest, working hard. Anytime that we have victims in Rockdale County, our staff work hard. They always have worked hard and making this county safe. The one thing that we will not tolerate and don't like to tolerate is people becoming victims in this county and in this community. And this staff has proven that is not tolerated in Rockdale County. So I'm actually proud of the work that they do each and every day for the citizens of Rockdale County. So they know that that's basically a mission for this agency, and they worked hard on that mission today and tonight and yesterday. And we've accomplished what we need to accomplish, is to get someone off the street from committing a crime such as this.
So the
charges currently now is felony murder, aggravated assault, battery, and home invasion. And there could be possible more charges. Again, this is an ongoing investigation, and we'll determine that at the conclusion of the investigation.
Was there anyone ever thought to be hiding him or just aiding him in any way?
We don't know yet, but again, during the course of this investigation, we hope if that turns out to be the case, we'll determine, make decisions at that time.
Have you determined or discovered a weapon that was used?
I don't have any details of that as of yet. This is just came new and suddenly, and so I don't know the details on that as of yet.
Okay.
Thank you.
Sure. Thank you. Appreciate it.
Thank you. Appreciate it.
Appreciate it. Hey, who on the ship in the vault? Who on the ship?
I'm gonna say this is crazy because the first officer said that they don't know each other. That's a lie. Jermichael Jones is from 1017 Brick Squad. Trouble is from MMB. Minding my business. So how you not gonna know one another? Make that make sense. But what I want to do is I want to do a moment of silence for Trouble real quick. You know what I mean? I'm gonna do a little 30-second moment of silence real quick. We can start that right about now. Rest in peace, Trouble. You know what I mean? You'll never be forgotten, bro. It's kind of hard. It was kind of hard today. So, and before I do what I do, real quick, I heard somebody say, I heard somebody say to Angie, "Can we talk about hijacking funerals?" Now, the hermaphrodite said that, and see, I don't talk about them bitches because all of them bitches. I said it. Now, when I release the hounds and females start putting hands on these whores, I don't want nobody saying, "Dana, you wrong." But what up, Prima? But I'm at my dog's funeral, man. It's not my fault that y'all motherfuckers don't know nobody. It's not my fault that y'all dumb motherfuckers clout chasing off of R. Kelly. At the end of that, I don't have to clout chase off of nobody. These are my legit friends. People I call on a regular fucking basis. And I'm glad Angie ain't take that. And I'm glad Lovely One sat up there and really took up for me. I appreciate that, sis. But some of you bitches that's going around sending your pussy pics to broke motherfuckers, don't put that shit on me. Don't put that shit on me. And because you thought you had to come up off a broke nigga. You defending the nigga that said your pussy stink, bitch. There's nowhere in hell I will be defending anybody that went public and said something foul like that about me. Matter of fact, let's take it here. I was in your city and you went silent. Talking about talk to my nigga. No, bitch, I'm talking to you. Because you the one that did it. So now, since you want to say that, here's what I'm going to say to you. The same motherfucker that I had in Tennessee, the same motherfucker I'm going to have for you in New York. Okay? So keep that same motherfucking energy, okay? Now, let's go ahead to the dummies. Let's go ahead to the dummies. When you had y'all leader clout chasing off of R. Kelly, jumping in front of court TV and this and this and this and this, ain't nobody say nothing. Motherfuckers thought it was funny. Motherfuckers laughed at y'all. But let's keep the shit a buck. I didn't have to clout chase off of anybody. I didn't have to. I'm not going to play the music because they're going to try to distract me. However, up here, you see red and white and black. You feel me? This is Trouble's friend section. You can't get in there unless you got credentials. You can't get in there unless you got credentials. Back here. Here's his mother. Here's his family coming in. Boosie is on this side somewhere where the speakers were designated. But I'm standing right next to Boosie's brother. Boosie originally supposed to be sitting over there where I'm at. So clout chasing off of who? You bitches clout chasing off of me. Let's keep it a buck. I'm not looking for the camera. I'm seeing 11 here. I ain't know it was a camera right there directly on us. Mika, paralyzed. So I don't know what you motherfuckers talking about. I don't know what you motherfuckers talking about. But let's keep it a buck. Let's fast forward it. That was a moment. That was a moment. Hold on. I'll show you.
We never were. When he had his children, I had his back. He loved his children. He was a good father. He was a good man. He was a good brother. He was a good businessman. He knew the big God. He knew it. And I hate that we here right now. I would never, I mean never be the same. I don't care what no one says. That was my heart. Don't tell me how to feel. Don't tell me what to pray. That was my heart. And he's gone. I know his spirit with. And at the end of the day, that's the whole. I love you,
Bro. For 20-some years. And I could never find the words.
Big scales.
Oh, my LBB brought us up here with the way he created. Y'all boy come up here with, bro. It ain't no disrespect.
Lou Williams.
Trouble creation. The way he created. I tried to write shit down. I tried to do everything in the world to find the words. But I just couldn't find the words. Because this was a real special guy, man. He just never judged nobody. Always accepted people. So ambitious, fearless, a woman's man. Or somebody just an all-around great creation, man. And we always used to talk about not leaving the earth, man. We never planned this. We used to always talk about, bro, how we gonna make it act. You see what I'm saying? And this guy right here, man, he brought all us together, bro. I'm talking about millions different personalities, but everything was real and genuine with you, man. And today, bro, I just really want to give you your flower, bro. I can't make no speech, bro. I want to tell you, bro, we love you so much, bro. And I appreciate you, bro. Your brother, man. Back in high school, I gave him the name Dude. And ever since then, you know, I ain't called him trouble in 15, 20 years. I always call him Dude. You see what I'm saying? He just always been there for me, always made sure, man. Scale, come on, bro. Scale, come on, bro. Scale, come on, bro. Whatever he made sure, he made sure people who really loved him, he made sure they was in whatever he doing, man. He gonna not stand in front of you. He gonna stand
Who that
beside
right
you.
there in the back?
You see what I'm saying? And I want to tell you, bro, from the bottom of my heart, man. Yo,
Tell my boy, thank you. So
you, bro, your name will forever ring on. We ain't got no hand out.
I want to tell Trouble, thank you. He always supported me, you know. My nigga, you know, and I'm hurting for y'all because I'm hurting for 5 years. You know, I went with him 30 years, you know, so I just want to tell that nigga thank you, you know, for that was my boy, you know, and I just want to tell him thank you, that was my boy.
Hold on, Boosie. Hold on, Boo.
Got no hand dog in here right now, bro. But we gonna hold our hands up right now, bro. And we gonna take that toe, bro. Good health, longevity, and big old bag. Thug life. Thug life, man. Love you, brother.
Tell my boy thank you. So I want to tell Trouble thank you. He always supported me, you know. My nigga, you know, and I'm hurting for y'all because I'm hurting for 5 years. You know, I went with him 30 years, you know, so I just want to tell that nigga thank you, you know, for that was my boy, you know, and I just want to tell him thank you, that was my boy.
So with that being said, man, I mean, it's crazy how people want to try to do whatever, you know what I mean? But you don't see me on here false flagging. One thing I can say about Trouble, you ain't had to be in a gang for him to know that you were real. Yesterday, seeing him for the viewing shook me a little bit. Today, seeing that casket there rocked me a lot. Seeing this, really ain't nothing to play with, bro. Really ain't nothing to play with. Really ain't nothing to play with, bro. Really ain't nothing to play with, bro. Really ain't nothing to play with, bro. Because when you bond with a nigga, That's for life and after. So while y'all motherfuckers playing, that shit really set different with me. That shit really sit different with me. The shit really sit different with me. And see, and that shit make me want to snap on all you fuck niggas. Like I said, I don't gotta get on here because I ain't set my boy up. I ain't set my boy up. A chick did. So I don't gotta live in guilt. But I tell you one thing though. I tell you one thing though. I'm gonna do this one time for my nigga. Rest in peace, Bankroll Fresh. Rest in peace, Trouble. Do this for my niggas. Y'all niggas don't know, bro.
Boy, you's a bitch and you know the shit. Somebody go check him, I got a split. How you gon' trip on another nigga? About a bitch who ain't in your bitch. Why you ain't flip on them other niggas? Who took your shit, nigga? You a bitch. Tryna get more niggas juice you up. That's how I know you ain't built for this. They asking questions, say what I'm doing. They don't really know, they just know I'm doing it. They say the school is a bad influence. They tryna say I'm a bad influence. Cigarella, clean on backwoods. Strapped like a sheriff, I'm that good. See me and my bitch from a bad hood. Ran up the rap, bitch, we back to it. You pussy niggas know that you in street. We get it all on the front street. We get it all off a back street. Real nigga know where them pads be. You tryna trip out the dirty bitch. Let this shit fly like the dirty bird. The money, it flowing like spoken word. My girl, they dirty than dirty girl.
I got this shit, and nigga word to word. You talking that shit, bitch, you got some nerve. You nigga be snitching, you know I heard. Don't let these fuck niggas know that I serve. You wrong in that hoe and that pussy dirty. She sucked my dick and I gave her 30. That bum ass bitch wasn't even worth it. She say you broke, but you always working. Always be working, but still broke. Say you be selling your partner dope. I fuck your bitch and I caught the dope. Don't call my phone, let's block them more. I'm a real trapper, my spot the stove. He broke it rapper, just mad and broke. I'ma pull up and I let it go. I got the kilter and it 30 loaded.
You pussy niggas know that you in street. We get it all on the front street. We get it all off a back street. Real nigga know where them pads be. You tryna trip out the dirty bitch. Let this shit fly like the dirty bird. The money, it flowing like spoken word. My girl, they dirty than dirty girl.
I be the recipe to the scripts. I'm second out like I'm KLC. Free 350, yeah, he from the 3. Elays on sit there where I be. R.I.P. KP. Got a sister named P. Got caught stealing that Michelin. Now my arm flood with an AP. Know the nigga hate me. Cause these niggas ain't big. Better keep it on the sidewalk, nigga, cause you niggas ain't straight. I keep a big bankroll. On the track with backroll. Truck, big green, that's a fool to my team.
Pussy niggas know that you in street. We get it all on the front street. We get it all off a back street. Real nigga know where them pads be. You tryna trip out the dirty bitch. Let this shit fly like the dirty bird. The money, it flowing like spoken word. My girl, they dirty than dirty girl.
Go with your hating ass.
Just like everybody say, niggas.
Just that. Looking at her. It ain't my fault these bitches mad though. It ain't my fault that where the cat go. Get out your feeling, get a bag, oh. Walked in Javinci, clear the tail, oh. I bought the Bentley just to shit on all these bitches. I bought the rate just to give it to my nigga. I came from nothing, finally made it to the million. Yeah, I'll tell you. Stack them rats up to the city. Yeah. It ain't my fault your hoe won't fuck around with a real one. Yeah. Now she hate lane, she tried me out, she know the difference. Yeah. My boy with Johnny passed around on Sky the Pimp. Yeah. No MTV, but she won't see just how I'm living. Yeah, nigga, mind your business. Yeah, won't tell you about who I'm hitting. Yeah, just had a son. Yeah, put the other one on her titty. Yeah, two step like did it. Yeah, got a project, bitch, did it. Yeah, she know I get it. Yeah, get a box with Hello Kitty. Yeah, murder be the coast, so death the snitches. Yeah, she came with it, so I kept the digits. A relationship we got, one told you I dig it. Tell her the car, see I murder your bro, it ain't no limit. It ain't my fault these bitches mad though. It ain't my fault that where the cat go. Get out your feeling, get a bag, oh. Walk Ninja Venture, clear the tail, oh. I bought the Bentley just to shit on all these bitches. I bought the rate just to give it to my nigga. I came from nothing, finally made it to the million. Stack them rest up to the city.
It ain't my motherfucking fault that my wrist talk, even in the bitch dog. South Baton Rouge, it ain't my fault that I stick talk. Niggas mad I'm on, but I get my hustle off the click out. Blame it on the blues why I'm always in the bitch mouth. Bentley truck, what the fuck? It ain't my fault, I'm a street nigga. These niggas be telling my name and shouting my game. Feel like talking to a bitch who I fuck on the first night, nigga. It ain't my fault that your money ain't right, nigga. It ain't my fault. You don't smoke how we smoke, nigga. It ain't my fault. You don't drink how we drink, nigga. It ain't my fault. You ain't real like we real, nigga. It ain't my fault. You don't kill how we kill, nigga. It ain't my fault.
It ain't my fault these bitches mad though. It ain't my fault that where the cat go. Get out your feeling, get a bag, oh. Walk Ninja Venture, clear the tail, oh.
Yo, you know what, yo? I just think about some things, right? You know, it's like I got a lot of emotions going on in me right now. Like I really wanna cry. Cause I ain't gonna never see my boy again. Can that remind me so much of where I'm at right now? That remind me so much of where I'm at right now. Like I'm the free agent right now. And I said I was gonna pick where I was gonna go, who I was gonna rock with. I done made my pick. And see, and just like E. Dewey Smith said today, he said, when LeBron was faced with the decision, in Cleveland, a lot of people was mad. They ain't know how to act. They was burning jerseys, all that shit. But in South Beach, they was happy. They was throwing a party. Something similar to what's going on now. Down here on earth, we crying because we ain't gonna never see trouble again. We ain't gonna never hear that smile again. I'm never gonna hear him say, Dana, stop playing me, boy. You already know what time it is, boy. You gotta make it pop, boy. If you ain't making it pop, it can't be done. You know what I'm saying? It really fucked with me. So I'm gonna say this. For 3.5 years, I watched Team Kale stab me in my motherfucking back. And I know a lot of people tuning in like, Dana gonna say what I think he's gonna say. For 3.5 years, I watched Team Kale stab me in the back. And you heard me openly say, fuck Team Kales. I'm not Oak Cove material. So I can't go there. Then I heard a big fat fitting trees say, oh, you can't pick a side. You can't go nowhere because you beef with everybody. So now I'm going to give you my decision. My decision is fuck Team Kills. Fuck who don't like me. I'm staying home with my dream team. We all made a pact. The dream team is for life and after. We're a real family. There's nobody on here like us. So why would I leave? The people who love me and I love them back. Y'all better get real with this shit. A lot of y'all in this for R. Kelly. A lot of us are here for R. Kelly. But a lot of us are continuing this after the R. Kelly stuff is settled. I've asked the question. So many people talk about I'm for the injustice, but you only talk about Bill Cosby and R. Kelly. So what injustice are you for? What about the little dude that got killed by the police department and ain't nobody get indicted, and the parents had to bury that little dude and then turned around and the DA said, time served. You can come back to work. Where's the injustice? I don't see nobody out there hollering about injustice for Kim Fox's husband. I thought you stand up for what's right. I don't see nobody talking about goddamn Karl Malone. Where's the injustice? But that's all you see is motherfuckers talk about Bill Cosby, R. Kelly, and don't do shit and talk about the Innocence Project. Fuck the Innocence Project. What have they done to help anybody that they wasn't already helping? Make it make sense. Y'all fight for injustice. Let's talk about Deshaun Watson. Why nobody talking about that? Cause y'all not for injustice. Y'all not for victims. Because a victim is not just a woman. A victim is a man. A victim is a child. A victim is an elderly person. So y'all not for victims. Stop all that shit, man. If y'all really for victims, show that shit. If y'all really for injustice, show that shit. Dream Team is for what's right, and we show that shit. We got stories that's 3 months behind. Every day. We sending stories to one another. I got a story booming right now. Y'all want to talk about y'all for women's rights? Why nobody says shit about how Prima Donna and Sky Zone have been stalked on YouTube? Why nobody talked about how my son mama been stalked on YouTube? Oh, but that's about to come to a head. The 29th around the corner. That's coming to a head, baby. I told you, I'm going to get funky like a monkey, and I don't give a fuck. Let's make this make sense. Y'all want to talk about really stalking? Why nobody says shit about that fucked up ass phone call at an R. Kelly press conference? That happened by women. Oh, but y'all for women's rights. Fuck out of here. Y'all for injustice. Fuck out of here. I can't take none of y'all serious. Because you know what I noticed? A lot of you motherfuckers take a story that's a lie and run with it instead of vetting it. Let's talk about it. And Malik, let's talk about my home city as a Crip. Let's talk about it. Shaquetta, I seen your comment, but what do you want to talk about? What do you want to talk to me for? You don't got nothing to talk to me about. You did what you did. And I told you, I don't play games like that. With me, it's for life and after. Loyalty is a big thing with me. Y'all really want to get funky about it? Let's talk about this. Everybody had an issue when I walked away from Sylvia, right? How about the motherfuckers that walked away from Sylvia because the motherfucking grease got hot? Ain't nobody saying about them. Now everybody want to walk away from Sylvia and give an account. All of you bitches complicit, including the channel that y'all run to. Motherfucker shitting trees. Or fitting tires. That's what we gonna call it, fitting tires. That shit ain't gonna stop with me. Fuck wrong with you? When it's up with me, it's up. And I ain't saying it's stuck, but that shit is permanently stuck. I'm not pressed about views, none of that shit. And I purposely play music so motherfuckers can't be like, oh my God, he's making money. I ain't making shit off this video. Because I get it out the mud. It's a method to my madness. And y'all about to see it unfold very soon. So until motherfuckers start putting their actions into what their mouth say, don't come at me with no bullshit. Don't come at me with no bullshit. Y'all stand for y'all stand for what's right? So why nobody want to put pressure on a lady that got trouble killed? Or I ain't gonna say got trouble killed, but she was the Achilles heel. Why nobody putting pressure on that? Oh, but y'all stand for rights. Or I guess because what she did and because she a woman, y'all believe everything she said. I get it. And for this side, oh, it's not R. Kelly, so I don't care. What the fuck are you in this shit for? How about the fact fitting tires got tight with Kwame Brown disrespecting the fuck out of a black man live with all kinds of curse words because Kwame told her to get him. You know what? Check this out. Shit like that. I couldn't have been oh boy. Because I would have got up there and I just would have listened. And as soon as she finished, I would have aired her ass out. And Kwame would have stopped and that would have showed the biasness on him. I was an advocate supporter of Kwame Brown. I got the fuck off there, bro. Nah. So like I say, the Dream Team is not just a slogan. We're a brand. And it's for life and after. And the 4 principles. You got to love one another. We got to develop trust for one another. You got to respect one another. You got to be honest. And you got to believe in a higher power. More importantly. And we're going to rise together. AKA one love. One love. Prima said, and there lies the problem. Some got mad because they wanted to use Kelly fans to branch out. Some wanted compensation for their work, and others just crabs and roaches in the barrel. Goddamn right. That's the problem. Motherfuckers like Prima Donna, myself, Georgia Girl. And then let me speak on that. Dream Team. I don't care what a motherfucker say. We ain't giving nobody the benefit of the doubt. If we know what you're about, fuck your benefit of the doubt. Take that shit, take it to God. I deal with it when I get to the crossroads. And I tell him the same thing. Lord, look, fuck that benefit of the doubt. I don't give a fuck. Georgia Girl page got spammed and hacked. Well, not hacked, but spammed. And it's like a disruption. Yo, I don't play with demons. I destroy demons. I get them out of here. I stomp them out in person. That's what I do to demons. And I still say that was fucked up. Because no matter how a motherfucker feel about me, you don't go to nobody else's page and do that shit. And like I say, a lot of motherfuckers got balls on this internet. But fuck the internet. I'm a scary motherfucker on the internet. In person, I'm going to show you just how much balls my shit drag. And if you think you're going to have somebody with you that's going to try to aid you and do something to me, I want you to know one thing: I don't feel pain. So if you ain't killing me, as you said you was going to do, I'm fucking them up too. So your best bet to stay away from me, because I'm going to make a motherfucker remember I was there. And it's definitely not a joke or a game. One thing I love about over here, we hold each other accountable. Even when I don't feel like being bothered. So on that note, a lot of you motherfuckers that want to be us, I get it. Learn from what we do. Oops. The problem is we don't reveal our secrets. We don't reveal our secrets, and we support one another over here. So now I'm going to give you the good tea, as y'all call it. Now the spill is, when I share people out, the dirty prize send people over there to try to recruit. I'm going to say this and I'm going to leave it here. Anybody that I share out over here, solid, ain't going nowhere. So if y'all think y'all can recruit somebody that I share out, it's a dead story. But homie, you keep asking about Christian. The 29th, you're going to see him. I'm going to show you what he do. And you're going to get to see in live and living color what Christian is, who he is, who he a product of, and what his temperament like. Y'all done tried everything that y'all can do to get me from going to the court. Y'all done went and got Shaquetta alive for y'all. All that shit. That shit ain't stopping me. It's going to hurt y'all though in the long run. It must feel real bad to ignore the fuck out you. You done tried to pick beefs with DJ Tyson. You done tried to pick beefs with Grown Man. You done tried to pick beefs with Levi. You done tried to pick beefs with me. And all of us looking at you laughing. While you got that little sex traffic little girl sitting on camera looking like a fucking walking death zombie. And you happy about that. Clothes all hanging off and come on, bro. Men don't carry their women like that, bro. That's why I don't even be pressed. Because I will never stick my penis in nothing that you ever had, including seen fishy. She don't use enough Massengale for me. Anytime you say her vagina stink, something gotta be wrong because you stink. You stink. So for you to say her vagina stink, that's a bad situation. Georgia girl, and I'm gonna continue to share you out. I'm gonna continue to share Fantasia out. I'm gonna continue to share Tomorrow's Sports Leaders Network out. I'm gonna continue sharing everybody out. I'm gonna continue sharing Big Val. Yeah, Faces and Beyond. That's Stockholm Syndrome right there. Oh, I'm gonna go ahead and back him because he gonna put all the stuff out there. Nigga, he already said your pussy stink. You can't get no worse than that. And check this out. And for the motherfucker that put the video of me eating pussy out there, check this out. You must be a lonely, desperate faggy to put a video of another man eating pussy. Are you taking notes? Are you trying to get key points? But go ahead, do what you do. Keep sending that traffic my way. Only thing that's going to happen is they're going to get over here and see how much we're family, and they're going to want to party and stay with us, and they're going to say, that motherfucker's stupid. Yeah, he's stupid, dirty, and dumb, and desperate. So, hey, Midas, that's the point that we on. And because YouTube ain't doing nothing about it, that's a lawsuit against YouTube. Trust me, but I'm already on it. I got some lawyers on it already. They drafting up some stuff. Yeah, Glenda gave him a video, and them niggas went and made fake pages and started putting it out there. Like, that shit bothered me. And you better hope I don't come to Bolingbrook and fuck your mama. And then put that on video, nigga. You better hope I don't fuck your mama and put it on video and your sister. Fuck out of here. Are you playing with a totally different breed? I'm not that guy. Yeah, Prima, that's definitely a charge. Exactly. I got some lawyers drawing it up. I got the video from when the shit was said and a week after when the shit was produced. I got it all. I'm just saying. That nigga talk more. Oh, if I can't go to court, no, man, you worry about the wrong shit. I don't give a fuck about that court shit no more. I'm coming with a purpose and with a reason. That's the problem that you got to worry about. I don't give a fuck about the court shit no more. I don't give a fuck about getting barred out of courts. As long as I make my statement, I get barred out of courts. That's what you got to deal with. A nigga who ain't giving a fuck no more. That's all I'm going to say. And Malik tried to warn you motherfuckers. What happens when I go rogue? Hey, Diane. Face is stupid. I believe you would fuck his mama. You did Jasmine. Y'all not going to never let that go, are y'all? Man. Like I say, and because a nigga don't show what he is in real life, a lot of niggas take it for granted. Okay. I read demons well. LBVS. I'm still waiting on the video for y'all to send Prima Donna that I was in Vegas 4 years ago with Azriel on her birthday. I'm still waiting on that video. I'm still waiting on the video with me and grown man in the pool together. I'm still waiting on that video. I mean, y'all got me waiting like a motherfucker. Like, why? And then let me address this one last thing. Don't call me trying to squash shit with somebody who don't have nothing to do with the shit that you said. If you ain't said, how in the fuck do I know about it? And one thing about me, if I fuck with you, I'm not going to record you. But when you play with me, I will always have a witness. And I don't give a fuck how you feel about me. I ain't never meet you. I don't give a fuck about you. I might have played like I gave a fuck, but that gave a fuck card gone. So it is what it is. If I don't try to reconcile with you, don't call me. That's on God. But some of y'all, if I hear y'all voice, I throw up. It's only one dude I'm waiting to hear from. That's on God. That's on God. So at the end of the day, it is what it is. You ain't gonna get no solid in this. Simple as that. Appreciate you, Callie. You ain't gonna get no solid then over here. And then I'm gonna go ahead and I'm gonna say this. If I was ever a fraud type motherfucker, you think Prima Donna be over here? Look at all the people that tried to pull Prima Donna. That's all you gotta do is genuinely be you. That's the problem. A lot of you motherfuckers sent y'all representative. And when y'all representative got thrown out the house for being a fake motherfucker, y'all wanted to get mad and click up. For what? What do y'all have to offer me? Nothing. A lot of y'all got y'all shit from me. So if y'all got shit from me, what do y'all got to offer me? Let's keep it a buck. I seen a lot of you over on Larry channel praising him. But y'all for Rob. Right. That part, Prima. And drop the ball. And drop the ball. Whole won't. Not you, I am Jam. He said, not me. Harassment by individuals employed or known for collaborating with heads of racketeering organization funded initially by Homeland Security. Facts. But see, Midas, they don't understand that. They not on that type of time that we on. Oh, and I am going to Midas, I'm going to tell you now, I got to upload that podcast, bro. And I got to title it just like you titled it. The Setup of R. Kelly and Dana J. Or or I think it was the RICO of R. Kelly and Dana J. The world needs to hear that. That part, Vi. The other side is just that. The other side. It is what it is. What Faces and Beyonce? They not on Prima level. They couldn't relate. They can't. They can't. They don't understand the whole strategy. I understood the assignment. The reality is everybody has flaws, yet it ain't attractive to no one when you clearly see people motives. Facts. Facts. And you clearly see people clout chase. Oh, I'm going to go try to get the... For what? You don't know these people. And the first thing they hear is when they hear Tim Savage, Jongelin, Gerald Griggs, and them say my name. Oh, Dana in bed with them. Man, fuck you. Y'all don't got nothing to offer. And I ain't in bed with them. I just went to war against them. And when you go to war against a motherfucker and you really mean something and you destroy some shit, they remember you. They remember you. And Huff said, I actually don't miss them. It's way better now. Facts. It's facts. So I'm going to say this before I get out of here, man. Nah, hold on. I'm about to show y'all something. Hold on. For the people who ain't get a chance and see the funeral, you know what I mean? I'm going to show y'all something. Something that really was dear to me that happened at the funeral. Feel me? I'm going to show this real quick.
She find that counts, I can't beat him. But all the losses fall, they get weaker. Baby, can you lay on to me right now, cause I can't find mine. Can you lay on to me right now, cause I can't find mine. Ready be the business to get life. Free Detroit, they gave my son a life. D-Day, they robbing just for strikes. No more, listen real. Baby, mama taking me to court. I locked up the 5 for child support. Tryna run my back, but I can't let her. Dunking bullets, I'm tryna get with her. Sensitivity at the field, watching, they been trusting. I gotta walk my own partner, not the building. I always been my own robber, I don't need your stick. I always been my own problem, till I need the switch. Can't nobody else once I need them. Feel like my auntie find that counts, I can't beat them. But all the losses fall, they get weaker. Baby, can you lay on to me right now, cause I can't find mine. Can you lay on to me right now, cause I can't find mine. Whoever thought I'd be there, on the net. Still looking for my mom running with skittles. I'm in prison when we lost AJ, I walk pitiful. Just the Timberlake, I cried a river. They sideways like Hango. Call me like they just a Bango. I was on the road and doing slow. I can't fall. I'll take your full household. Houses ain't the same, keep your mouth closed. Boy, but they don't with me when I'm out though. So me a while, I understand it's only about you. Myself in there for people. Can't nobody else once I did them. Feel like my auntie find that counts, I can't be.
cause I can't find mine. Can you hear watching me right now cause I can't find mine. When anybody in the house,
Facebook ads are killing your.
Zone 6 will never be the same down here. Man. But look, check this, man. I'm about to go watch the replay of the game. Love every last one of y'all. Like I said, this Dream Team was nothing for me. On God, I'm out of here. Y'all be blessed. Have a good night. Love every last one of y'all. Peace.
The boy never let me in. Sick with the medicine. On the block distributing right with the medicine. Haters don't like me. Heard they wanna fight me. Teflon at your chest. I bet you can't fight these. Mad cause I'm getting dope. Pillsbury ill flow. Niggas love to move slow. You sick of me, don't care though. Yes, I'm a savage. Out for the cabbage. Catch the boy armed up, full metal alchemist. Yes, I'm ill. And yeah, I'm so real. Coward ass niggas coming home without an appeal. Damn, how this getting done? Tell me what's the outcome? Anybody want to see me? Tell them where the fuck I'm from. Patrol homes, red rum. Yeah, we get the job done. Out trying to stack chips. Make these haters so sick. If they sick of that, then they really gonna be sick of this. Santa Claus Viper. Haters, Merry Christmas.
Swimming in you. Hey, little mama. Said I wanna take a dip in your pool. Just go for a little dive, yeah. Hey, yeah, yeah, yeah.